Good morning, and welcome to the 5th Annual ACC NCR Diversity, Equity, and Inclusion Conference. My name is Veronique Stacco. I'm Assistant General Counsel at Willis Towers Watson. Additionally, I'm an ACC NCR board member and Vice President of DEI. We have an amazing morning scheduled for you and are grateful that you joined us today for a conference titled Strategies in a Post-Affirmative Action World, Impacts of the Harvard Decision. During this conference, we will discuss whether and how a company should adjust their DEI initiatives or policies in response to the recent Supreme Court decisions, Students for Fair Admissions versus Harvard and Students for Fair Admissions versus UNC. Additionally, we will examine how these decisions may influence recruitment and hiring practices, as well as retention and employee development efforts. Before we get started, let me share two upcoming chapter DEI events we hope you will mark your calendar and attend. The first is our annual Corporate Scholars Reception on June 6th in the DC offices of our Diamond sponsor, Paulsonelli, one of our biggest events of the year. It is a fun evening of networking with our scholars, who are interns from local law schools spending their summer in legal departments, and our peers. A few months later will be our annual All Affinity Group gathering on September 19th in DC. Each year, we select a new venue for members of our 7 affinity groups and allies to gather. Invites for these upcoming events have been or will be sent out in the near future. For a full list of upcoming DI programming and events, please check the ACC NCR website. Let's get started with today's event. We are thrilled that many of you are joining from your home or office, and we extend a special welcome to participants at 3 locations throughout the DMV. We are grateful to Davis Construction, Fannie Mae, and LMI for hosting our members to engage with the conference and enjoy lunch. We are thrilled to be able to offer in-person community building together with this remote conference. Before we get started, let me share a few housekeeping notes. Today's conference will be recorded and will be available at a later date. Comments today should not be publicized without permission, should not be construed as legal advice, and do not represent the positions of any company, firm, or the chapter. Please direct your attention to a few features that will help you enjoy and participate in today's program. We want this conversation to be interactive, so please place all questions in the chat box at the bottom of the screen. The speakers will do their best to get to the questions. For those of you in the in-person locations, please use the chat box on the computer in your room to post questions. Please feel free to turn on the captions for a running transcript by clicking the button labeled Show Captions at the bottom of your screen. We also suggest that you use the speaker view rather than gallery view for today's conference. We are so grateful to our platinum sponsors, Crowell and Mooring, and Paul Hastings. Both have been longtime supporters of our chapter and are here today to share compelling content. You will hear more from them later. But first, we have a special treat. We are thrilled to introduce our esteemed guest, Stacey Hawkins, Professor of Law at Rutgers Law School and Diversity Consultant. Professor Hawkins will begin with a presentation on how the SCOTUS affirmative action ruling impacts the DEI landscape. Following her comments, Hannah Brescian, Vice President, Deputy General Counsel, Labor and Employment at CACI International, Inc., co-chair of our DEI Advocates and Allies Subcommittee, and a member of the ACC NCR Employment and Labor Committee, will moderate a further discussion with Professor Hawkins. They will also take questions from you, so please add your questions to the chat box and they will take them as there's time. Let me share a bit more about Professor Hawkins' background with you. Professor Stacey Hawkins is an award-winning teacher and scholar. She formerly served as the Vice Dean at Rutgers Law School in Camden, where she teaches courses in constitutional law, employment law, and an original seminar on diversity and the law. She is the recipient of numerous honors, including the 2023 Chancellor's Award for Diversity, Equity, and Inclusion Leadership, the 2022 BELSA Champion for Social Justice Award, and the 2018 AALS Derek A. Bell Award, which is given to those junior faculty who exemplify a commitment to diversity and critical race theory in their teaching, scholarship, and service. She was also named Faculty of the Year by the graduating class of 2013 and Co-Professor of the Year by the graduating class of 2018. She is a recognized expert on employment law and diversity, has given testimony before the U.S. House Judiciary Committee, and has been interviewed or quoted in various news outlets. In addition to teaching, Professor Hawkins has spent more than 2 decades advising and training clients in both the public and private sector on issues of workplace diversity. Professor Hawkins and Hannah, thank you so much for being here today. I am eager to hear your remarks.
Thank you so much, Veronique. I appreciate that very gracious introduction. And let me also give a special thank you to Shannon Graving, my former colleague who invited me to be here this morning with all of you. As a former practitioner in DC, I have fond memories of attending ACC events, and I'm happy to have a bit of a homecoming with this presentation. So again, thank you for having me. I've been asked to do a bit of table setting for your conference today to really lay some legal groundwork around the Supreme Court's decision this past summer in the cases involving Harvard and UNC, and to talk about my research on diversity in the workplace more broadly and how these decisions might impact the legal landscape. So I'm going to share my screen and start a presentation and talk us through what's going on with this most recent case. But quite frankly, I always like to start with the context, because I don't think you can talk about the Students for Fair Admissions cases without talking about the man behind the litigation. And that man is Edward Bloom. And the architect is not a moniker that I have assigned to Edward Bloom. It actually comes from a podcast that is hosted by NPR. The title is More Perfect. Anyone who is, like me, a con law nerd will find it extraordinarily engaging. There is an episode dedicated to Edward Bloom, and the title of that episode is The Architect. And what Edward Bloom is a self-described architect of is a project to dismantle the use of race in public life here in the United States. And it's important to understand that this has been a long-standing and broad-based project by Edward Bloom. So we associate him with the Students for Fair Admission cases involving Harvard and UNC, but he started this project a long time ago, and he's been to the Supreme Court several times. And so the first kind of context in which Edward Bloom began to litigate these cases challenging kind of race consciousness was in the voting rights context. And so many of you may be familiar with that 2013 case, Shelby County versus Holder, which essentially gutted the Voting Rights Act by taking away the preclearance provision. And again, the Voting Rights Act, as we know, is the kind of landmark legislation that helps protect against race discrimination in voting. And so again, Edward Bloom was the man behind that litigation and an area where he has litigated several cases all the way up to the Supreme Court. And then, of course, we have the cases that involve higher education. And you can see the SSFA versus Harvard and UNC case there in the middle, 2023. But there is a case that Edward Bloom filed that precedes that. Many of you may be familiar, in fact, with the case Abigail Fisher versus the University of Texas at Austin. That went up to the Supreme Court actually twice, in 2013 for the first time, and ultimately in 2016 for resolution. Edward Bloom filed that case as well. In fact, he filed it against the University of Texas because it is his own undergraduate alma mater. I'll talk more about what the Supreme Court said in that case. But again, I just want to point out that this is a part of a larger project on behalf of Edward Bloom, and a project That is not done. And so you can see that he's already filed another case in the higher education context against the U.S. Military Academy at West Point. Again, I'll talk more about that in a moment. But the final context, which he has just entered, and that is of most, I think, interest to everyone in this call, is in the contracting and employment context. And again, he created a different organization, American Alliance for Equal Rights, to file these cases against a number of entities and employers. The Fearless Fund case is a case involving a venture capital firm that is owned by some women of color, and he is challenging a grant-making program that is directed towards Black women in particular. Many of you are probably most familiar with the cases that he filed against Morrison and Forrester, Perkins Coie, and Winston and Strawn around their diversity scholarship programs. Again, more about that later. And his most recent case is a case against the Smithsonian, which also has a similar internship program for people of color. So again, this is a ongoing, right, a project that extends, back in time, far before the Harvard and UNC cases, and that continues into the present, and we expect into the future. So this is a player to really watch in this space. Oh, by the way, he also filed back in, I believe it was 2020, challenges against the board diversity rules that had been promulgated both by the California legislature and by NASDAQ. So again, he's just extraordinarily busy filing these cases across a range of domains, all of which have to do with either kind of race consciousness or diversity programs specifically. And like I said, he's been doing this for some time, and he shows no signs of letting up. So let's talk about the diversity admissions context, which is the context that the Supreme Court has been most engaged in. And so it gives us some insight into what the Supreme Court might do in the employment context. But certainly they've given us a concrete guidance around the use of race in pursuit of diversity in the higher education admissions context. So most, if not all of you, are familiar with the fact that the first time the Supreme Court actually addressed the issue, at least with a majority consensus around the interest of diversity in higher education, was in 2003 in the case involving the University of Michigan. In particular, the Grutter case involved the law school. And in that case, the court kind of adopted a finding that said that the educational benefits that colleges and universities seek to attain by amassing a diverse student body actually constitutes a compelling interest. And if you're familiar with, constitutional equal protection standards, you know that any use of race is subject to strict scrutiny, and that standard requires that the person or entity being challenged identify a compelling interest and then demonstrate that the way that they pursue that interest is narrowly tailored. And so in the first step in satisfying this strict scrutiny standard, the court did accept that this interest in pursuing student body diversity so that the colleges and universities could obtain the educational benefits, it did constitute a compelling interest. It would be capable of satisfying strict scrutiny. And then in terms of looking at how colleges and universities were using race in pursuit of that interest, the court said several things. One, that colleges and universities were only required to consider workable race-neutral alternatives before engaging in race consciousness. And workable was very important because there were a lot of things that the court said were not necessary. Most notably, these were always selective colleges and universities, and the court was very clear that the colleges did not have to compromise their selectivity in order to become more diverse, right? So becoming less selective was not really a workable race-neutral alternative. The court also said that race must be used in both flexible and individualized ways. It can't be mechanical. Of course, quotas have long been prohibited. And so that was another criteria that was applied to the use of race. And then finally, the court said, as the court has always said about the use of race, that it must end eventually. Now, in that particular case, Grutter v. Bollinger, Justice O'Connor wrote the majority, and she actually alluded to the fact that perhaps in another 25 years, colleges and universities would no longer need to use race. And at the time, most people considered that just dicta, not a binding holding of the case. And Justice O'Connor explained that kind of prediction was not based on any concrete evidence. It was merely a reference to the fact that it had been 25 years since the court had last considered this issue of race consciousness in higher education admissions, which was in 1978 in the case involving Alan Bakke and the University of California at Davis Medical School. And so she projected out another 25 years and says, once the court considers this issue again in 25 years, maybe by that time we won't need to use race any longer. I mentioned that the first case that Edward Bloom filed in the higher education admissions context was Fisher versus Texas. And in 2016, the court essentially doubled down on each of these holdings from Grutter. And it affirmed that the educational benefits of student body diversity are indeed a compelling interest, and all of these criteria about the use of race remained applicable to college and universities' use of race. Fast forward to 2023, and the court is now considering a consolidated set of cases against Harvard and UNC. And the court really shifts its kind of findings dramatically, despite the fact that Chief Justice Roberts attempts to assure the public that he's not, or the court is not, overruling Grutter v. Bollinger or the precedent that had been affirmed in Fisher around the interest in race-conscious admissions and the pursuit of student body diversity. Nevertheless, here are the kinds of holdings that the court had on each of these points. So in terms of the interest in student body diversity, the very interest that the court in Grutter and Fisher said was compelling, the court said now, the same articulation that had been upheld in Grutter and Fisher, the court said this articulation is not sufficiently coherent or sufficiently measurable to permit the kind of strict scrutiny review that is necessary when colleges and universities consider race. So again, it seems a complete kind of 180 from the Grutter and Fisher holding, and nevertheless, the court said this is not a reversal of Grutter and Fisher. This is just a kind of application of that to a different result. Insofar as considering whether or not there are any workable race-neutral alternatives, the court didn't even discuss that issue in the Harvard and UNC cases. Rather, what the court focused on was the fact that Harvard and UNC were engaged in a use of race that the court defined as not only amounting to negative discrimination, particularly against Asian American students, but also stereotyping more generally. And again, the court had said in Grutter and Fisher that race has to be used in an individualized and flexible way. And so stereotyping is antithetical to, right? It's kind of the converse of using race in an individualized way. And so the court said that was problematic. And then finally, again, to this point that it must eventually end, rather than accept the 25 years as dicta, the court adopted that really as a part of the holding in Grutter and said, well, there are, yes, 5 years remaining on that 25-year clock, but these colleges and universities don't show any signs of abandoning their use of race in the next 5 years. And so we're going to impose the end of race consciousness now. There's no point in waiting that additional 5 years. If there's no likelihood that they will come to their natural conclusion within 5 years, they should simply end now. And again, you can make your own determination about whether or not this seems like a holding that can be squared with Grutter and Fisher, but I can tell you that at least one justice, actually not even one, both Justice Thomas and the dissenting justices, who included Justices Sotomayor, Justice Jackson, and Justice Kagan, all agreed that this holding amounted to an effective reversal of the Supreme Court's prior precedent in Grutter versus Fisher. Grutter and Fisher, I apologize. And so there are a few important caveats, kind of call out about the Supreme Court's holding in the Harvard and UNC cases. And one of which is that all of the prior cases from Bakke to Grutter to Fisher had all involved public colleges and universities. None of them had involved private universities. And so there was an ongoing open question about whether or not the standards applicable to private colleges under Title VI were the same as the standards that have been articulated by the Supreme Court under its equal protection jurisprudence that were only applicable to public colleges and universities. And the Supreme Court resolved that question in the Harvard and UNC cases, Harvard obviously being a private university, by saying that Title VI and the Equal Protection Clause, their standards are coextensive, and anything that violates the Equal Protection Clause also violates Title VI. And so now we know that all colleges and universities, both public and private, are subject to the same standard. And whatever the Supreme Court has said about the use of race in pursuit of student body diversity around public colleges and universities are equally applicable to private colleges and universities. There was an important exception carved out by the university for military academies. And the reason for this is that the military has been a strong advocate on behalf of the benefits of student body diversity since the Grutter case. So in 2003, a group of retired military generals filed an amicus brief in that case, and they have filed amicus briefs in every case that has been considered by the Supreme Court since then, including in the Harvard case. Essentially making a plea for this interest in student body diversity on behalf of the U.S. military. And so the court said, while we have found in this particular case, the interest in diversity articulated by Harvard and UNC are not sufficiently coherent or measurable to satisfy strict scrutiny, we reserve judgment on any interest in diversity that might be articulated on behalf of military academies who were not before the court. Even though they had filed amicus briefs, their claims of interest in diversity were not actively before the court for consideration. And so the court said, we reserve judgment on whether or not that interest could satisfy strict scrutiny. Enter Edward Bloom, who immediately then filed suit against West Point, challenging their diversity programs and now forcing the court to articulate whether or not the interest in diversity on behalf of these military academies can survive strict scrutiny in ways that the interest articulated by Harvard and UNC could not. Now, there's already been a little bit of preview of that case because Edward Bloom sought an injunction pending litigation, right, to prevent West Point from administering that policy. And it was denied by the trial court, and they appealed that up to the Supreme Court, and the Supreme Court did issue an order saying that they would not enjoin that policy pending the litigation. Again, they were clear that this was not a comment on the merits of the litigation. Nevertheless, they were not willing to enjoin that policy pending the litigation. Finally, and this I think is the most important, the thing that I take the most heart from as a diversity advocate and a diversity consultant, and I think that all of us doing this work can, is that the majority opinion in the Harvard and UNC cases were very clear to distinguish between two different types of race consciousness in the admissions process. One is considering the mere fact of a student's race. And if you heard the oral arguments in these cases, a lot of the advocates and justices refer to this as the checkbox consideration of race. And so we all know that on applications, whether it's for employment or for college admissions, applicants are asked to self-identify their race and ethnicity, often by checking a box. And it is that information that the court is disallowing colleges and universities to make use of in the admissions process. The mere fact of a student's race, as indicated by that checkbox information, is no longer permitted to be considered in the admissions process. However, a student's experience with race as disclosed voluntarily by the student in some other area of the application is permissible. In particular, the court said, quote, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so again, the mere fact of a student's race, as indicated by the checkbox, not permissible, but a student's discussion of how race affected them is fully permissible. And so again, I think that that's an important idea to carry forward into the employment context when we talk about how race is properly considered under a prevailing law. Um, Now, this is an area where I have done some unique research, and that is trying to kind of predict what would happen if the Supreme Court were to consider a case challenging workplace diversity efforts under Title VII. And while the Supreme Court has not yet considered such a case, a number of lower federal courts have, both at the district and at the circuit court level. And so back in 2015, I published a paper, the Fordham Law Review, that did a survey of decided federal cases from 2003, which of course is the first time the Supreme Court endorsed the interest of student body diversity on behalf of colleges and universities, and 2015, the publication date of that article. And there were 44 cases in all that had been decided by every circuit court in the country on the issue of workplace diversity. And I analyzed those cases to determine what patterns I could discern. And I think that there are a couple of important observations to make from this information. The first is that if you look at that kind of top line data point, it looks like there's a fairly even chance of success on behalf of plaintiffs and defendants. Out of those 44 cases, about 19 plaintiffs were successful, about 22 defendants were successful. It seems almost as if it's a toss-up for employers in terms of defending their workplace diversity efforts against challenge under Title VII. But if you drill down into the actual facts and analysis in those cases, there is a far more kind of revealing pattern. And that pattern is that if you look at cases that are essentially adjudicating what the court treats to be affirmative action plans, that is, plans that are really explicitly considering race and or gender in their decision making, often, although not exclusively, but often in the interest on behalf of the employer of remedying some sort of manifest imbalance. But even if they are not articulating that justification in particular, once an employer concedes that there is an explicit consideration of race and gender in decision-making, it is treated like an affirmative action plan. And in those instances, employers overwhelmingly were unsuccessful in those cases. And so again, out of those cases, 20 of those cases, 15 of them employers lost, right? That's a 75% loss rate when you're talking about efforts that are treated like affirmative action plans because they consider the explicit use of race and gender in decision-making. Conversely, what I'm calling diversity plans, which are these plans that are really about the business interest in diversity that do not involve explicit considerations of race and gender, those overwhelmingly were more favorable for employers. And so again, out of the 22 cases that were really not explicit considerations of race and gender, but were really just in the general business interests of diversity, employers were pursuing, right, workplace diversity. Employers won 19 of those, which is an 86% success rate. Being more granular, there are two standards under Title VII that can be applicable. One is the Weber-Johnson standard, when a employer, again, concedes that race or gender has been an explicit consideration in the decision-making process. The Weber-Johnson standard is applied. It is an extraordinarily high burden for employers to meet, particularly after the Supreme Court's decision in Ricci v. Di Stefano in 2007. And employers won none of those cases, right? Like 0 of the cases that were litigated under the Weber-Johnson standard were successful by employers. Conversely, the McDonnell-Douglas standard, which is that burden shifting standard where the plaintiff bears the burden of proof, and we know that that's a fairly high burden of proof under which plaintiffs are rarely successful, holds when we are talking about a reverse discrimination cases oftentimes, but certainly discrimination cases that involve challenges to diversity plans. Employers were overwhelmingly successful in defending those plans under the McDonnell-Douglas burden shifting framework. Finally, in this same article, I looked at a number of the most common diversity practices that are used by employers in the workplace, and using the decided case law, which address each of these practices in turn, I rated them from least defensible under the case law to most defensible. And again, as you can see, affirmative action plans, by which I mean efforts that are done explicitly on the basis of race and gender in their decision making, those are the least defensible. Employers were least likely to be able to successfully defend those under Title VII. And again, you move through tiebreakers. This was often speculated as something that employers might be able to defend under Title VII, given the Supreme Court's existing precedent in the admissions context that race was permissible, right, as one of many factors in the admissions context, at least before the decision this past summer in the SSFA versus Harvard and UNC cases. And so many people assumed that, well, using race as a tiebreaker in the employment context would similarly be permissible as a plus factor. But it turns out that lower federal courts that had considered whether or not employers can do that under the standards applicable to Title VII often found that those practices were not permissible, right? Because Title VII forecloses the consideration of race and gender, except when done under a valid affirmative action plan. And so again, you can see tying compensation to diversity goals incurs some moderate risk of legal liability. Affinity groups, although I will say that these groups are most susceptible to legal liability when they are exclusive on the basis of race, ethnicity, or gender, as opposed to whether or not they're open, right, and available for access to all people. The most defensible efforts are general diversity statements or goals. Courts often had very favorable things to say about an employer pursuing diversity as a general business goal and targeted recruitment. Again, this is not taking any concrete employment action on the basis of race, ethnicity, and gender. Even if you are targeting certain populations for recruitment, you are not taking any concrete employment action. So there is very little, if any, risk of liability under prevailing case law for those practices. The final thing that I will say, and I will only kind of allude to this briefly because I know that there are going to be additional panels later on in the program dealing with some of the kind of supplier diversity, recruitment, and hiring practices. But I wanted to let you know that I have started updating the federal case analysis that I had done previously, although it was before the Supreme Court issued its opinion in the SSFA versus Harvard and UNC. So I pulled another set of the decided federal cases challenging workplace diversity efforts. And this time I went from 2015 through 2023, again, pre-SSFA. And one of the things that I can say is that the trends were the same. I was seeing identical trends, which is to say that when employers did not admit to any explicit consideration of race or gender in their decision-making, and when they were subject to analysis under McDonnell Douglas, overwhelmingly employers were successful in defending those diversity plans. And conversely, if there was an admission of explicit considerations of race and gender, which was the case, by the way, with the Perkins Coie, Morrison and Forster, and Winston Strawn, right? Those programs, those firms admitted were exclusive on the basis of race, ethnicity, and or gender, at least in terms of their description. I think that those firms would contest whether or not they were ever administered exclusively on that basis, but at least the description, which was what Edward Bloom was relying on, the public kind of facing promotion materials about those plans, describing how they are targeted to sue. And that's really the reason why they were susceptible to suit. And of course, more recently, there have been a couple of cases involving government contracting, both the Small Business Administration and the Minority Business Development Agency, which target disadvantaged businesses. But in defining disadvantaged businesses, they give a presumption that businesses that are minority-owned businesses are by definition disadvantaged. And two different cases have said that that presumption of disadvantage on the basis of race and ethnicity is inconsistent with the Supreme Court's new precedent disallowing the use of race under equal protection. The last thing that I will say is that the Supreme Court just decided last week the kind of Muldrow v. City of St. Louis case, not a case that is directly on point for workplace diversity efforts. The issue was actually whether or not plaintiffs need to allege an adverse employment action in order to state a claim under Title VII, and if so, what kind of level of impact or harm needs to be alleged. And the lower court in that case had said that there needs to be significant harm. And then the court said that while there needs to be some harm, right, there needs to be some adverse action to state a claim, that the plaintiff does not have to show significant harm. And so this was kind of a compromise position. It was not as far as the plaintiffs wanted in terms of all they have to do is show that, race or ethnicity was a part of the decision making, that there is some harm that is required as a allegation of proof under Title VII, but it need not be significant. So there were some discussions in the oral arguments for that case about how that impacts diversity programs, because again, many people thought we can take, race and ethnicity or gender into consideration, right, if it does not include any adverse impact on people's employment. And Muldrow kind of raised the prospect that you could have Title VII liability without adverse impact. Again, the court did not go that far, but there is now a question about what kind of harm is sufficient to constitute that adverse employment action. And so a broader range of activity than employers might have otherwise anticipated might actually be actionable under Title VII. So I will stop there and hope that that provides a nice foundation for both having a discussion with Hannah as well as setting the table for your subsequent panels this morning.
Yeah, Stacey, thank you so much. This has been a really great legal substantive discussion. I certainly can say I've learned a lot, and I really appreciate your legal research as well throughout the years. I can tell you I think it really helps us in terms of as we're developing our DEI programs and assessing the level of risk, just having your knowledge, right, throughout the years, just measuring that risk. I think it's been, very, very educational, very helpful. I can say, one question, right, that is probably in on a lot of people's minds. While the Supreme Court's decision in SFFA only applied directly to race as a factor in university admissions decisions, there is a lot of discussion around its impact to private employers under Title VII. Could you give us your thoughts specifically on this topic?
Yes. So I think that one of the things that I like to point out, and I was actually pointing out even before the Supreme Court issued its decision in SSFA versus Harvard and UNC, based on my research, is that the reality is that the standard under Title VII had always been far more restrictive than the standard under the Equal Protection Clause that the court had been applying to higher education admissions. And so there was no reason to believe, even before the decision came down, that no matter what the court said, that the kind of restrictions on employers would change as a consequence of the decision. In fact, what has happened is that in raising the standard for colleges and universities, they have essentially leveled the playing field to where employers already were under Title VII. Again, there really was only a single instance where employers under Title VII were permitted to make explicit considerations of race and gender, and that is under a valid affirmative action plan. And the vast majority of employers are not engaged in, right, their race consciousness or their diversity efforts pursuant to some sort of valid affirmative action plan. And even if they were, I would caution to be careful because, like I said, the case law demonstrates that it is increasingly difficult, if not impossible, in a post-Ricci world to effectively defend those affirmative action plans against challenge. And so I think that while the SSFA versus Harvard and UNC case was a significant, right, intervention for colleges and universities, it's going to dramatically shift the landscape of higher education admissions. It's really not going to have any impact, or it should not have any impact on the way employers, whether in the public or the private context, are doing their workplace diversity efforts, because under Title VII, they were already far more constrained than those colleges and universities were.
Okay. And I would like to discuss affirmative action plans and affirmative action generally. So the Supreme, and I guess I'll break it down into two buckets. I'd say voluntary affirmative action plans And then mandatory affirmative action plans. A lot of our audience today are federal contractors. So first, addressing voluntary affirmative action plans. So the Supreme Court's Weber decision does, you mentioned, allow for voluntary affirmative action programs if they're remedial, temporary, and correct past discriminatory practices. Where does Weber stand today after SFFA?
So like I said, I mean, I really do think that many people point to the Weber-Johnson standard, and I think that the standard we really need to be concerned about is Ricci v. DiStefano, because in that case, because previously the court said, you don't have to get to the point of legal liability in order to engage in voluntary affirmative action, right? Some sort of manifest imbalance in the workplace is sufficient. And that had been a standard adopted by the EEOC in its regulations, right? Creating the safe harbor for voluntary affirmative action. But you fast forward to Ricci v. DiStefano, 2009, I'm sorry, I think I said 2007. I think that case is 2009. And the court essentially says, there has to be, right, some indication of likely liability, right, on behalf of the employer before they can engage in race-conscious action to correct, right, that imbalance. And so, again, it's really difficult now to meet the standard for voluntary affirmative action, right, to take race explicit action or gender explicit action in order to correct a manifest imbalance. That's what the city of New Haven was trying to do in Ricci v. DiStefano, right? They were trying to prevent what they said was going to be a disparate impact. And the court said that liability was not clear enough, right? It was not proven to a degree of certainty that would allow you to take race-conscious action in order to correct that. I think we have to take that case seriously and understand that in the current context, we have moved sufficiently far away from the time when courts were embracing of remedial uses of race, that we can no longer rely on a court, right, to give employers wide berth to use those race, explicit measures, even under a voluntary affirmative action plan. And like I said, I think that the mandatory affirmative action plans that OFCCP administers and enforces, employers should understand that the regulations and guidance there are also very clear that employers engaged in mandatory affirmative action should not be making decisions explicitly on the basis of race and gender. What those plans require is affirmative outreach, right, and recruitment and, ensuring equal opportunity, right, in their decision making, but they should not be making employment decisions explicitly on the basis of race and gender. And the regulations and the guidance themselves make that clear.
Yeah, absolutely, Stacey. And thank you for clarifying the difference, right, of the standard that would be required under a voluntary affirmative action program that is meant to address remedial effects, right? And then what we're addressing as a mandatory affirmative action program for a federal contractor. Again, a lot of our audience here are federal contractors. They are required to have affirmative action plans, is required by the OFCCP. And under those AAPs, right, they have placement goals, they have utilization goals, it's benchmarking goals as well, right? And under those, that's part of your affirmative action requirements. And I think, you brought up really important points, right? That under the executive order, you still have non-discrimination obligations. And I think a really important point is that these are not quotas. A goal. Could you address some sort of that difference as well? The difference between a quota and what would be considered sort of a placement goal under one of these affirmative action plans?
Yeah, quotas have long been prohibited. They are per se unconstitutional, and they have been since 1978. The Supreme Court first said racial balancing in the Bakke case, but even in employment cases, the court said that quotas are impermissible. I want to point out though, Hannah, that really what the OFCCP anticipates, the major obligation on behalf of employers to do affirmative action plans is really about recruitment and outreach, right? There is a significant record keeping, obligation, but in terms of achieving those kind of utilization and placement goals, it's really about outreach, which is the reason why targeted recruitment is the most legally defensible thing under Title, right? That's what the government anticipates you are going to do. And if you're doing that effectively, they imagine that you are creating a more diverse pool of applicants such that if you are selecting, right, on the basis of merit and a legitimate business need, that race and gender need not figure into that calculus because you are selecting among a diverse pool simply those people who are most suited for the jobs, and you're naturally going to get, right, the kind of diversity that you would like.
No, exactly. And then just switching to Muldrow, which you discussed at the end. So in light of the Supreme Court recently expanding the scope of adverse action under Title VII in Muldrow, do you believe this will have implications for employers' DEI programs and initiatives?
So it depends on how employers are administering their DEI initiatives and programs. So I am aware that there are a number of employers who administer leadership development or other types of training programs, mentoring programs that are exclusive on the basis of race, ethnicity, and gender. And often the justification for those is because those programs do not involve any adverse employment action. There is no promotion decision, there's no compensation decision, there is no hire or termination decision associated with those programs. And because of that, it has been presumed that there is not sufficient, right, adverse action to constitute, right, a Title VII violation. Muldrow now expands the scope of what constitutes an adverse employment action by saying, right, it doesn't have to be something as significant as a termination, a promotion, right, or a compensation. This case involved transfer, right? It involved a transfer that had less desirable hours and less desirable access to leaders and, I think, high quality assignments. And that's quite frankly the very nature of leadership development programs. You have more access to leaders, you have perhaps better access to work and high quality work. And the court suggested that those are significant enough in terms of the adverse impact on employees to support a Title VII claim. And so I do think that employers who have been administering those programs on a race or gender exclusive basis are reevaluating those in light of Muldrow. Now, it has always been my advice to employers based on my own research that even those programs should have always been opened up. Again, you can always target, right, selection for and participation in those programs based on race, ethnicity, and gender, right? You can make sure that the people you are inviting to apply or participate in those programs, represent the kind of diversity that you want in your organization, but you don't have to make them exclusive. It was never necessary, and it always increased the risk of legal liability. And I think that risk has only been ratcheted up now that the court has issued the decision in Muldrow.
Yeah, no, absolutely, I agree. And going to one of the caveats that you mentioned previously, although SFFA applies to both private and public institutions of higher education, the Supreme Court expressly noted that its holding did not apply to U.S. military academies, which are not parties to the litigation and might not present potentially distinct interests, right, that could warrant consideration of race in admissions. Could you give us your opinion on the difference of military academies and them potentially being able to articulate a compelling interest that would survive strict scrutiny?
So lots of people are speculating why the Supreme Court made this particular carve out. And based on my own constitutional knowledge, I would say that it certainly likely has something to do with the Supreme Court's extreme deference to the United States on issues of national security and kind of military interest. And so the Supreme Court might be signaling that they're going to continue to show that level of greater deference to the military on matters of national security than they would otherwise show to public actors on issues that don't involve national security. Now, I would say that even assuming that that's the justification for why the Supreme Court suggested there might be an exception for military academies, the military academies would still fundamentally be asserting an interest in student body diversity. That interest might be towards different ends than the colleges and universities that have been adjudicated so far, including Harvard and UNC, but it's still an interest in student body diversity. And so I do think that it raises the question and certainly the prospect that there are other ends, right? There are other justifications that can be proffered to the court that could support student body diversity in the future. The court simply said in these cases that the justifications proffered by Harvard and UNC were not sufficient. Now, they had no reason to proffer any different or other justifications because, again, those were the very same justifications that this same court, although differently composed, but the Supreme Court had accepted not once, but twice, both in Grutter and in Fisher. And so I think that it's going to force colleges and universities to think about different justifications for the interest in student body diversity and to try to construct interest that might be capable of surviving strict scrutiny in ways that the court said these particular articulations were not. In the same way that the Supreme Court suggested U.S. military academies might be able to articulate, right, justifications for student body diversity that could satisfy strict scrutiny. I think that that invitation should be open to all colleges and universities.
Yeah. So Stacey, what can we expect to see next from the Supreme Court in the DEI context if you had a crystal ball?
So there is no doubt that there is going to continue to be litigation in the higher education admissions context, and not just higher education admissions. So there are a number of other kind of diversity efforts that are being challenged. So of course, your members are probably likely aware of the legislative efforts across the country in various states, right, to prohibit colleges and universities from engaging in all manner of DEI efforts, whether it's having and staffing DEI offices to having DEI trainings or other resources for diverse student populations. Those efforts are already, again, being challenged, like I said, at the legislative level. And I suspect that there will be some litigation, right, to kind of tease out and refine what those laws mean and what's permissible and what is impermissible. Also, Justice Roberts, Chief Justice Roberts' statement at the end of his opinion in the Harvard and UNC cases about the difference between the mere fact of race, right, and a student's experience with race. I would imagine that there is going to be some additional litigation to really, again, refine what that looks like and what that means. Certainly, Edward Bloom sent out a letter to, the top 150, I think, or 200 colleges and universities after the decision and said, if you do not comply with the letter of, this decision, we will be suing you again. And, quite frankly, the interpretations of the kind of mandates of that case were far broader than many of us interpret the mandate from that case. So I think that there's a lot of room for continued litigation on, pinning down exactly what the contours of permissible uses of race in the higher education context are. But there's no doubt that, Edward Bloom, the architect, right, who has long been engaged in this project and who has, right, a strong track record of taking litigation all the way up to the Supreme Court, he's targeted employment and contracting next. And as I said, the Supreme Court has not had a case in the employment context, right, challenging workplace diversity programs. I think that that is likely to reach the court in the near future. And so I think, paying attention to what's going on at the lower federal court level, as well as continuing to watch, right, for signals in the higher education admissions context, are going to be useful for those of us who are trying to strategize around how to do this work, how to understand where the kind of risks lie, and how to make sure that we're positioning ourselves, in the most securely defensible way.
Yeah, no, absolutely, Stacey. And now I'd like to invite our listeners to include their questions in the chat box. I know we have a lot of listeners also from the different listening locations. There's one I see right now. I'll go ahead and read this. So I've seen even very liberal organizations change their DEI functions to EI. Do you think that was a decision based on the cases you cited, or is it something else?
So I think that it is based on a kind of confluence of events. But I think one of the largest kind of phenomenon driving that change is the legislative effort, right, to kind of legislate against DEI. So again, there are some states where DEI is actually prohibited as a matter of state law. And it's not just prohibited for colleges and universities, it's prohibited on behalf of state entities. And so I think if you're in Texas, if you're in Florida, if you're in Alabama, Mississippi, I think it's Iowa or Idaho, I can't remember which of the two, but I think there are about 10 or 12 states now that have this legislation on the books that prohibits colleges and universities, and in some instances, broader public institutions, from engaging in any kind of DEI work. And diversity, I think, is the kind of largest target of these efforts because conservatives, the conservative opposition movement, has defined DEI as this kind of liberal indoctrination. Many fewer people take issue with equity and inclusion, but when it is appended to diversity, right, it's the whole bailiwick, right? And so these laws often target DEI writ large, but their real objectionable feature is diversity, which they, again, improperly, in my estimation, define as liberal indoctrination. And so I think that those legislative efforts, that kind of political and social attack on diversity, is what's driving the shift in the kind of nomenclature around these efforts. And it's funny because I noted on social media recently that everything old is new again. Because if you know your history, then you know that diversity is actually nomenclature that developed, right, to fill a gap in the aftermath of the kind of backlash against affirmative action, right? So it was all about equity, right, and equal opportunity. And there was a backlash against that, and certainly affirmative action. And diversity rose up, right, to kind of fill the space of equity and social justice work in the absence of the ability to really hold accountable entities to our equal opportunity standards. And so now diversity is the fall guy, and we're going back to equity, right? And so it's just this kind of cycle. But at the end of the day, I think what's important to know is that this work is not going to stop, right? It might be reinvented, it might be renamed, it might be evolved, right? Which I think is always a good thing. There are always ways to improve this work. We know that. And so I really do embrace and invite the opportunity to think anew about how we can be doing this work most effectively. And that includes, making it immune from legal challenge.
So I think we have time for, maybe one or two more questions. How would you suggest that employers could consider how race affected candidates' lives in the employment context in a practical way?
So I actually, again, have another article on this that I published several years ago in the ABA Labor and Employment Law Journal. Again, translating the diversity cases in higher education for the employment context. And it turns out that the reason why colleges and universities were using the checkbox information of race as kind of a proxy for student body diversity is because they really were pressed, right, to find efficiencies in their decision-making process, because they are making thousands of decisions at a single decision point, right, about admission to a single entering class. And in that context, right, it is really just a real data-driven quantitative process where they have to kind of quantify various aspects of a student profile and then evaluate those things in a very often kind of objective way. And so, yes, they were always asking students for essays, but even those essays usually were rated, right, on a numerical scale. And those numerical scales figured into, point systems that evaluated students. And so the nature of the admissions process is so different in that, they are really forced to use all kinds of proxies for selection that employers actually don't have to rely on, because, employees are almost never, I won't say never because there might be some instances in which they are, but employees are almost never hired without interviews, without meeting face to face with people who get to evaluate you, who get to talk to you, who get to ask you questions. In that context, there's never any reason to make a decision solely on the basis of someone's race, ethnicity, or gender. You can evaluate, right, whether or not someone's going to bring the kind of diversity of experience, the kind of cultural competence, the kind of, you know, experience, serving, diverse market share, or, addressing a particular, substantive issue on behalf of your company or your client base. And those are the kinds of decisions that are going to be highly defensible under Title VII, right? Because you can say this is not based on race, ethnicity. So we move from Weber Johnson to McDonnell Douglas, and then the burden's going to shift to the employee to prove, right, that it was because of race. And again, you can legitimize those decisions because employers, right, are much differently situated in college and university admissions officers in the way they make their decisions. And so I say that, evaluating people for who they are, right, this kind of individualized consideration that thinks about how this individual is going to contribute to your legitimate business needs, even including around diversity, is always going to be far more defensible than making kind of blanket decisions on the basis of race, ethnicity, or gender.
Great. Well, thank you so much, Stacey. This has been a really great discussion today. Veronique, I think we're at the hour, so I will turn it over to you for any ACC closing remarks for our session today.
Yes, thank you, Hannah. Excuse me. Thank you, Hannah. Thank you, Professor Hawkins. On behalf of our chapter, I would like to extend a special thank you to the both of you. We're so grateful for you to be here with us today for speaking. So we'll take a short break before our first panel presentation. So we'll see you back at 9:50. Thank you.
Welcome back from break. Let's get started with our next session. My name is Matt Seiler, Vice President and General Counsel at the National Community Pharmacists Association, and a member of the ACC NCR DEI Programming Committee. For our next segment, we are pleased to welcome our Platinum sponsor, Paul Hastings, to discuss practical advice on recruitment and hiring in the current climate. As a reminder, if you have a question during this session, please use the chat box at the bottom of your screen. The panel will address your questions as time permits. All remarks made by these panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC NCR. And now it's my pleasure to introduce our panel. Ryan Derry is a partner at Paul Hastings. His practice includes various aspects of employment litigation and counseling employers in multiple jurisdictions. He is a talented litigator, adept at handling complex single plaintiff, multi-plaintiff, collective, class, and representative matters from inception through trial. Sarah Besnoff is a senior associate at Paul Hastings. Her practice focuses on employment discrimination and pay equity, class and collective action litigation, pay equity audits and investigations, human rights and ESG counseling, employment counseling, and business and contractual disputes. Lindsay Jackson is also a senior associate in the employment law practice of Paul Hastings. She represents employers in all aspects of employment law in both single plaintiff and class action matters, including discrimination, retaliation, harassment, and wage and hour in both federal and state courts. Christina Alabi is a senior corporate counsel in employment law and compliance at Celonis. She has held various other in-house counsel positions, which include AGC roles at JP Morgan Chase and Peloton. She has over 13 years of experience advising C-suite and senior management and HR executives. Prior to her in-house roles, she worked in private practice as well as with the NLRB as an administrative law judge. With that, let's begin today's presentation.
Thank you, Matt. And good morning. We're grateful to be here and speaking with you today on behalf of Sarah, Christine, and Lindsay. Thank you for joining us, and welcome to our panel on practical advice on recruiting and hiring in the current climate. We're certainly grateful to Professor Hawkins for the last session, providing a fulsome background on the Harvard and UNC decisions and the potential implications of these decisions to DEI. As you've heard, the Supreme Court's Harvard and UNC affirmative action decisions have generated questions about the challenges and difficulties of the historical implementation of DEI recruitment and hiring programs such as diversity, internships, and fellowships. Our goal this morning is to provide very practical advice that private sector employees can take now and to evaluate their hiring programs for potential vulnerabilities to ensure the continued advancement of DEI objectives. As we think about it, as we think about the Harvard and UNC decisions, and we'll be talking about it, sure, those decisions put in place new parameters, there's new challenges we see in the DE&I space that we haven't necessarily faced before, but it requires greater creativity and thought as to how we're creating those programs. So that's what we'll be talking about today, of how we think about that with respect to the recruiting and hiring space. And to the end of what we're trying to accomplish today, we've structured our discussion and this panel to think about this kind of a DEI audit and approaching this as how we think about this. And DEI audits have become a product offering that we've started to do here at Paul Hastings in light of the Supreme Court's decision in Students for Fair Admission. So we're going to walk through different areas to evaluate and look at within your workplaces or other workplaces in those lines. And to that end, so we're going to be talking about what you should be doing right now to audit or evaluate your DEI practices. And for our agenda, we'll start with a brief employment law framework primer. Then we'll spend the bulk of our time talking through an audit of typical hiring practices. We're going to address practices for pipeline considerations such as internship design, the use of diverse slates, and then discuss publicly setting goals for representation, then hiring logistics such as record keeping and training. And with that, and without further ado, because we have a lot to cover over the next hour, I'll turn it over to Lindsay.
Thank you, Ryan. So on the next slide, or next couple of slides, I'm going to just take a few minutes to give you a quick primer on employment law frameworks. So if you go to the next, awesome, thanks so much. So to set the stage, we want to refresh everyone on Title VI and Title VII, which fall under the Civil Rights Act of 1964. And so Title VI prohibits discrimination on the basis of race, color, or national origin in any program or activity that receives federal funds or other federal financial assistance. Title VII prohibits discrimination in employment on the basis of race, color, religion, sex, or national origin. We also want to highlight that technically nothing changed for employment law after the Supreme Court's affirmative action, Harvard and UNC decisions. That decision was about Title VI, or those decisions were about Title VI and not Title VII. And even before the decision in summer 2023, race could never be used as a plus factor in an employment decision. Briefly turning to Section 1981, the statute provides all persons within the jurisdiction of the United States shall have the same right to make and enforce contracts as is enjoyed by white citizens. This is a Reconstruction era law specifically targeted toward equal contracting rights for formerly enslaved people. Nevertheless, in the 100+ years since, courts have expanded the law to what is referred to as reverse discrimination claims, in which a white plaintiff claims that someone did not contract with them due to race. Reverse discrimination cases are permitted under Section 1981 pursuant to the 1976 Supreme Court case McDonald v. Santa Fe Trail Transportation Company. In addition, another interesting area of law under Section 1981 is that while it is technically unsettled, it is likely that corporations have standing to assert Section 1981 claims as well. In Domino's Pizza versus McDonald, a 2006 Supreme Court case, the court noted the courts of appeals to have considered the issue have concluded that corporations may raise Section 1981 claims. And in making that statement, they cited a case where standing was predicated on being a racial justice organization. Similarly, in Comcast Corp v. National Association of African American Owned Media, which is a recent 2020 case that came out of the Supreme Court, the court recognized a Black-owned media company's Section 1981 claim without directly addressing the questions of standing of that company. This means that we've seen reverse discrimination claims by white-owned companies against grant programs or diversity programs targeted to minority-owned companies. And at the state level, almost every state has a public accommodations law. These laws can be used by customers, clients, and also independent contractors and suppliers to bring claims of discrimination against corporations. They are written more broadly than Section 1981 to encompass protected characteristics beyond race. And we provided a list of characteristics noted in Virginia and Maryland's laws on this slide. Notably, similar to the 1981 area, corporations likely have standing to bring public accommodation claims.
So against that backdrop, let's go ahead and let's turn to our quote unquote audit and what we're going to be discussing this morning. And again, as I mentioned at the top of the hour, we want to be clear here. Our goal is to help meet your goals and establish what you are interested in doing with respect to DE&I. As we all know, there has been a lot of political focus with respect to challenging DE&I. Many companies, some of your companies likely may have been focuses of letters or correspondence. Certainly law firms across the United States were focuses of letters and correspondence from senators and others suggesting that we step back from DE&I discussions and implementation of those programs. And so what our goal here is today is to not back away from those programs, but how do we do so from a litigation minimizing of risk perspective, or a PR minimizing of risk perspective, because that's what, as we'll hear about, many of our companies are facing. So to start that off, let's go ahead and turn it over to Sarah and Christina, who are going to discuss diversity fellowship programs, which they'll talk about has been certainly one of the areas of high-level focus recently.
Well, thank you so much, Ryan. So yeah, we wanted to start the audit with what we have seen following the Harvard and UNC decisions have been really a target of the pivot of Edward Bloom, who you heard a lot about from Professor Hawkins, and organizations like his have really shifted pretty quickly from affirmative action programs in universities and colleges directly to fellowship and internship programs that were targeted towards diverse applicants. So for our first audit topic, we're going to really talk about this as a pipeline consideration. So a pipeline consideration is how you're sourcing your candidates and also how you're ensuring that your entry-level recruitment practices are allowing you to have the type of diversity you want to see in your senior level roles. And a common method of building that type of pipeline and building DEI into particularly your entry-level recruitment practices is through a diversity fellowship or a diversity internship program. We have up here in the first gray box the traditional model, where a lot of these programs and internships were explicitly limited to applicants who were a member of a designated protected class. This is just one example where it was limited particularly to people of a certain race or as a member of the LGBTQ+ community. So again, these programs have become really the center of the bullseye for Edward Bloom and also for others and organizations like them after the Harvard and UNC decisions. Last summer, we saw the high-profile lawsuits against two law firms, Morrison and Forster and Perkins Coie, in these two cases. So these were lawsuits against a very standard practice in the big law universe of providing diversity fellowship and internship programs, particularly for 1Ls, to applicants who were a member of certain protected classes as a really deliberate and successful approach to building in diversity into a pipeline and to competing for top talent. For example, Perkins Coie's fellowship was limited to 1Ls and consisted of a paid summer associate position that had a $50,000 stipend and would likely lead to offers of employment. And it was limited to people who met one of a delineated list of protected characteristics. Similarly, Morrison and Forster's at the time, applicants had to meet 5 requirements, which included an explicit diversity requirement of membership in a historically underrepresented group, which was inclusive of racial or minority, ethnicity groups, and also LGBTQ+ status. And with that, in mind, what we're seeing then was this challenge where, as Lindsay was describing, they brought the challenge under Section 1981. So it was, interestingly, it was a nonprofit organization claiming that they had a member who was otherwise qualified for the 1L position, except for the fact that they were not a member of one of the protected groups that was specifically delineated in the application criteria. And again, sometimes we talk about it with the UNC and Harvard decisions. One of the most long-lasting and important holdings there was just that organization had standing at all to bring that suit, because it really opens up the floodgates on what standing means in terms of a membership organization. And we're seeing that again, where well-funded and well-resourced membership organizations are the ones actually suing on employment decisions, rather than having a clear or specific person who did not get it being the actual plaintiff. So we have a membership organization being the plaintiff here, and they sued under Section 1981, claiming it was a violation of the contractual rights of the member, that they were not allowed to apply, but for the fact of their race. And as you likely have heard, both of those law firms changed their criteria and have explicitly removed the required criterion that someone meet a membership in a protected class in order to apply for their fellowships. So let's think about, that's caused a bit of a wave. A lot of our clients are now reconsidering their programs. And this is where I wanted to bring in Christina as well to talk a little bit about some of the different approaches we've been seeing to address this type of litigation risk. So we've really divided these into two main approaches we've seen companies do. So the first is the top row, where what they've done is they've modified the protected characteristics at issue such that it's a much longer list, with the goal of beating the but-for causation in Section 1981, where in order to prove a Section 1981 claim, you need to show that it was but for your race that you didn't get to contract. And when the list is longer of what is defined as a protected characteristic, the belief is that that will provide greater safety and security for the program, because there will be many reasons why someone did not get the job, and there will be more opportunities and avenues for people to be considered qualified under the criteria of the selection process. So we're seeing things, for example, where one approach is to say you must be a member of an underrepresented group, but you get to self-identify. And that's not policed and it's not defined by the company. The other approach is to just add such a lengthy list, again, that the hope is to beat but-for causation. On the spectrum of kind of risk and conservative approaches, that's an approach that is still taking on some amount of risk. Notably, both Perkins Coie and Morrison and Forster had other criteria listed that would qualify as a member of a protected group, and they were still sued, with the idea being that if you could hit everything but for the race, you would have still been admitted into the program. Would be the theory there. So the more kind of small c conservative approach that companies have taken who want to continue their diversity and fellowship programs is this bottom row, where the requirement to be a member of a protected group is removed entirely, but some additional point is made to clarify that this is still intended to be a recruitment tool for a more diverse audience and a more diverse applicant pool. So we've seen that where either it's removed entirely, but it's still explicitly stated that people are encouraged, and maybe there is an attendant outreach effort to certain communities to apply. So an approach where you're still stating it as a diversity fellowship, you're still really trying to expand your applicant pool, but you have technically removed the requirement. And then the other two is something we're also seeing very frequently, which is now the addition of an essay. And the essay becomes an opportunity to either focus on having overcome a hardship, or separately, how you contributed to DEIB within your school community or as a leader in your neighborhood. And we're seeing these essays kind of standing instead as a proxy for leadership in the DEI space, rather than the proxy being specific membership in a protected group. So I'm curious, Christina, have you seen, I know you're a member of a lot of organizations, kind of cross-industry, cross-cutting, and obviously you've served in a number of in-house roles across different companies and industries. What are you hearing about companies kind of addressing this change, and what box are you seeing companies decide to put themselves into on this chart?
Thanks, Sarah. Yes, so I am a part of a number of organizations, and this is essentially the first summer that we're kind of all testing it out to see, no one wants to be on the front page of the New York Times and be that first target. And so everyone's kind of like, oh, what are you guys doing? How are you changing this? What I think I'm seeing more of is everyone, or more people are going towards the essay requirement. So you're speaking about your lived experiences. So it's not as explicit as you have to be a member of this historically underrepresented group, which is the issue that we've seen with the law firm suits. But if you can speak to that in your personal statement, in your application to the program, and then on the other hand, the employer is training those that are reviewing the applications to know, what is it that we're looking for our candidates. And then we also have a few other best practices that we'll get into. So that's what I'm seeing. But again, this is the first summer, so we're all trying to just move cautiously, but still with the goal in mind, as Ryan shared, that we do want to be more inclusive and, address historical wrongs.
Mm-hmm. That's exactly right. And in full disclosure, Paul Hastings, we still have our diversity fellowship program as well, because it's been a common approach, because it's a really successful approach in recruiting top tier talent into your entry level pool to have the type of diversity you want to see long term at the company. But Ryan, I know you have some tougher questions for us, so I'll throw to you.
Yes, I think what we wanted to do here was, again, with kind of that discussion, complicate this a little and talk about some hypos. So as you talked about, Sarah, so even if a company is broadening the applicant pool for diversity fellowships, let's talk through what some of the risk areas for that remain, right? And for the first example in our hypos, what if the diversity internship pays interns in specific URGs more money than other interns in the same role? What do we see with respect to risk profile with respect to that type of program?
Absolutely. So this is a risk we've been counseling on even before the Supreme Court's decision, which is there has been a latent pay equity concern risk where you have a internship program where you're hiring a diverse applicant with maybe that $50,000 extra stipend, or with maybe a stipend for school supplies or to help pay towards school, or a higher stipend for a bar prep or things like that, where you are paying them in effect more than other people in the internship program for arguably the same work. And so we see people a lot of times, there's kind of a set number of roles within a bigger cohort that are targeted to diverse applicants, and those specific applicants end up with a higher pay than everyone else in the cohort. And that creates a concern of, well, if these two people are doing the same job, and the only difference is that one is a different race or one is a woman, and that's why they're getting paid more for the same work, you're going to have a pay equity issue, particularly in some states with kind of broader, more sweeping pay equity laws like California. So that is a concern that we've been working with certain companies on, even predating this decision. And I think that is certainly heightened in this era, though, where you're seeing a lot more emboldened reverse racism, reverse sexism, plaintiffs, and, as we said, nonprofits that are well funded bringing these claims on behalf of a member. So I know, Christina, I know your organizations you're with have spoken about this as well. What kind of strategies have you seen companies employ to make that at base differentiation, to show that maybe these two roles are not so similarly situated that a pay equity claim could lie, saying that the only difference is race or sex that is causing a difference in pay?
Thanks. So I'm seeing some companies add an additional component, like a capstone presentation at the end of the summer, or an ongoing, like through the academic year, something to reach back to kind of keep that pipeline going, or a recruiting aspect or a presentation training requirement throughout the summer, however you mix it in, just to further differentiate the roles. You could change the timing of it so that perhaps a diversity fellowship is a little bit longer. Again, it's still not a zero risk option, but these are just some considerations and practical guidance that we're trying to provide. But again, you want to be mindful of the pay differences, especially with all the pay equity laws, New York, California, Illinois coming up. It will be a target because, you know, these are going to be publicly posted on what those pay differences are. And I think that, you know, there's other ways that we can do it where you're partnering with other schools and organizations, and so that they're also doing some added, it's an added plus giving to the community, or like I'm going to weekly or bi-weekly to, you know, do this extra thing with the community or volunteering or something of that nature, just to make sure it's different, but also coding the programs differently in your system so that there's not a direct pay comparison if you run a study of the roles. Again, there is still risk associated with these advice that we're giving, but these are some ways to slightly differentiate the roles.
Absolutely. We're seeing the best case scenario if you get sued for this is being able to point to job descriptions that list different essential functions and a job architecture recording that is explicitly differentiating the roles such that they wouldn't be swept into an obvious comparison if you're doing a statistical study. So we're seeing exactly that. We've heard a lot of companies talk about like campus ambassador, you know, having those extended responsibilities for students after the fact. So it's definitely something to be keeping in mind, though, particularly as companies are reevaluating and, you know, auditing these programs to begin with. It's a good time to check in with those.
Yep.
And also, I'd just add what we're seeing there's, right, the effort of true differentiation, true kind of altering the program, right? So as we're talking about different things and we're talking about different perspectives there, ensuring that it's truly differentiating, this really are the essential functions. There's maybe a different goal or a different impact to the extent it's a campus ambassador and they have a different outreach expectation than other people within the workplace. So it really is different expectations for those roles. But let's flip the hypothetical on us now. So let's kind of take the instance, what we're seeing some employers do, which is, well, let's just blow open the doors and now it's open to all individuals to apply to this program. But the stated goal, and it's very clearly the goal, is still to recruit individuals from underrepresented groups and persons who typically were not in those roles. So what type of risk do we see there, mitigation or potential risk that still remains from that?
Yeah, so there's definitely, we're seeing a lot of companies just trying to stay out of the bullseye, right? But knowing that diversity fellowship and diversity internship programs are a really strong way to build a pipeline. And the goal, though, is not to just change it in name only such that you're just pushing off a lawsuit for 2 years from now, you know, when these organizations move from the most obvious ones that have explicit criteria on their website to looking a little bit more in the weeds and still have risk because you've still really internally limited this program to consideration explicitly of race when making decisions or consideration of gender when making decisions. Because to that end, there really is still a risk of a disparate treatment hiring claim to the extent that you are making a decision still explicitly on race, even if it's technically open to everyone. And this is a bit of a placeholder for the final slide we're going to have, which is practical advice, which is that doing this needs to be accompanied with training to remind people that this is, you know, not a wink, wink, nudge, nudge situation, but truly an explicit consideration of race should not be considered and has never been legal. And two, I need to make sure that your record keeping on why applicants are selected is very strong and has a lot of detail about all of the amazing reasons that you chose to hire someone. And this is particularly, we think, important in light of the Supreme Court's decision, because in the context of university decisions, the court was explicit in stating that, yes, you can still consider a really well-written essay about overcoming difficulties or being a diverse member of the community, but it cannot be used as a proxy for race. And they specifically called that out in that Supreme Court decision in a way that it was really signaling similarly for programs like this that are switching from an explicit consideration of race to a use of a essay, that it cannot be used as a proxy for an explicit consideration of race. So make sure you're thinking about the logistics that need to accompany these changes as well, like training and record keeping.
And from that, I think we're going to shift away from internship fellowship programs and broaden our discussion of pipeline considerations. I think we're going to bring Lindsay back in here to talk about some of the other approaches we see companies applying to increase diversity in their pipelines beyond kind of the specific internship and fellowship programs.
Thanks, Ryan. Yeah, so I want to dovetail off of what Sarah and Christina were talking about and transition from individuals in colleges, graduate schools who are applying, specifically going out and applying to programs. Another pipeline option for increasing the diversity or maintaining the diversity in the workplace is to work to have a partnership to build that pipeline. So on this slide at the top left, or I guess on the left-hand side, we've provided some examples of partnerships, but generally the idea here is to broaden, it's just a classic approach to broadening the applicant pool through active participation in those types of diverse groups, and also through targeted charitable giving. So the first example that we wanted to highlight was Alt Finance, Apollo Global Management, Inc., Ares Management Corporation, and Oak Tree Capital Management announced a 10-year, $90 million industry first initiative in which it was titled Alt Finance Investing in Black Futures. So the initiative is designed to diversify the alternative investment industry by attracting, training, and providing career opportunities for college students attending 3 historically Black colleges and universities, so HBCUs. Alt Finance was launched in partnership with Clark Atlanta University, Morehouse College, and Spelman College, and it's intended to provide students with clear pathways to careers in the alternative investment industry. The initiative has 3 primary components. The first is a mentored fellowship program. The second is a tailored virtual institute, and the third is a scholarship program. And then below that, there's a similar example where Barnard College, a women's school, also has a targeted scholarship program partnering with Bridgewater Associates to get more women in the investment industry. So many companies, we have seen many companies start to partner with school systems and even as early as technical high schools. Another option is remote work. Remote work can be a way to expand applicant pools beyond a limited geographic pool. It's something that, as a result of COVID-19, a lot of companies that weren't previously considering it are now more familiar with. Although while a lot of us are leaving the remote aspect work, or at least COVID-19 in the rear window, remote work is still an opportunity, not just to keep your employees safe, but also to expand your diversity. If businesses do not have to limit their recruiting efforts to candidates located within commuting distance of their offices, they can engage with potential new hires based on their qualifications and suitability for the role rather than where they live. And you can think about this on a small scale level and a large scale level, right? It's the idea of hiring someone who is in a completely different state from you, but it could also be the idea of hiring someone who doesn't live in the community, in the city in which you are, like you're in the same city, but they live in a far away or more diverse neighborhood. And, you're just able to make them consider a job with your company because you've reduced their transportation cost. And then a third example of partnering is to consider working with industry or participating in industry groups. So we've listed a few of them here, but the idea is if you as a company have members in various affinity groups, if you're participating in networking events and outreach events with these affinity groups, it's a really easy way to, one, just build your network and get to know people in your industry, and 2, get to know potential contacts in a very low risk way, where people just have the opportunity to build their network and also get to know about individuals in their same workspace. But I want to broaden the discussion and bring in Christina. I mean, I want to get your opinion on these three, if to the extent you have any, on these three approaches, partnerships, remote work, and industry affinity groups, both from your perspective as an employee, someone who's worked in multiple companies, and from the perspective as, if you have one, as the employer, like what you have seen different companies considering and what works and what doesn't.
Yeah, I think I agree with all of these options. I think they're all great and they have worked. So I've seen it both firsthand and with some of my peers. The partnerships to the pipelines. I know there are certain HBCUs that are pretty popular that we know, but there are lots others that people aren't as familiar with. But if, organizations can go out into those different states and find those HBCUs, I think that would be a great opportunity to expand your applicant pool. I've also seen remote work, especially don't want to say thanks to COVID, but because of COVID, we've seen that we've been able to do certain roles from a different location from other than the commuting distance of the office, like you mentioned, Lindsay. And so I think that we have seen more diverse applicants because you're now opening up the pool. So it's not someone that lives in a certain area, but you can open it up. But you also, with that, I think we talked about this, have to be very intentional with the remote work because you want to make sure that that person, it's a thoughtful process. You want to make sure that the person still has the right amount of face time with leadership so that they're not just being hired, but they're retained and they're staying. So, maybe there's a aspect of bringing that person out to meet the team or certain offsites and things of that nature. But I have seen that work. I've seen it where, the legal interns or interns for any department are from HBCUs. I've also seen when organizations are really connected to certain groups, like you've mentioned here, NAPABA, NSBE, NELC, you do have more applicants because people who are from those groups will share the job requisition with their peers and their in-house listservs and their group meet chats. And so then you're getting that, that exposure for the job rec to certain people that you otherwise wouldn't reach.
Great, thanks for that perspective. That's really interesting. So the second area that I want to talk about are diverse slates. And so on this page, we have an example of one by Wells Fargo, and we have a couple of others that we'll show you as well. But just to start, a diverse slate is where your applicant list for qualified, which is important, the candidate needs to actually be qualified, for qualified candidates for the role includes people with diverse backgrounds, typically racial and gender diversity. And so you can see from, and you guys will get a copy of these slides, but we've provided examples from Wells Fargo, Meta, and Johnson & Johnson as an example of publicly disclosed forms of diverse slates. So Wells Fargo created a 50% diverse candidate slate and interview panel for senior roles. Meta, their public-facing disclosure is bigger. They note that they will set an expectation of diversity in their applicant pools, but they do not specify what that entails. And Johnson & Johnson states that they will require at least 2 diverse candidates, including women and or Black or Hispanic candidates, to be interviewed. Christina, have you considered, or any of your workers considered using a diverse slate before? If so, how did you set it up? Or certainly if you haven't, have you heard of anyone in the industry and like the thoughts that they are working through, issues that they're working through before they start using a diverse slate?
Yeah, so I think it's really important to also know your organization. So for example, like I was at a financial institution at my first in-house stop. And so that organization has been around for 200 years. Talent acquisition is a well-oiled machine. And so diverse slate is just part of the ethos. And I think you'll see that in other companies too. Startups, everyone's striving to attain that. It really, it's more effort, I would say. And also, I would also say that it's not just about having the diverse slate, but you should take a step back. And some practical considerations that I would share is that you should audit your job descriptions and remove like unnecessary requirements and unnecessary degree requirements. Some jobs may not need that. So that's also creating a diverse slate. Or audit your job ads and interview questions for race preferences and sex questions. So I was at an organization where anyone who would be on the interview panel had to go through interview training, and also anyone who was writing a job requisition had to take that training as well. So taking out certain words that, we all have our biases, that you may not realize that this could be tailored to males, or this could be tailored to other group. And so taking those words out to make them gender neutral or race neutral, so that more people are encouraged to apply, and eliminating interview questions once you have that diverse slate that target fit, because fit could be coded for fit to be more like the people in this organization. And if our goal, like we're all here for, is to be more inclusive and more diverse and equitable, then we want to make sure that, I think Sarah mentioned earlier, the right training, and we'll get into that a little bit later, for those people making the decisions. But I think that diverse slate it's more of an ethos and an understanding that that's what we want. And you also think we mentioned we want to avoid tokenism. So it's not just, okay, we've got the one person, and so check the box, we've done it. So that's some of the things I've seen. I know we'll share more shortly.
That's great. Yeah, and just as a reminder, it needs to be employed for actual applicants, right? This is not a check the box exercise. Just by way of example, in fairly recently, Wells Fargo was involved in a lawsuit in which they ended up prevailing, where they had adopted a policy that called for at least 50% of candidates interviewed for jobs paying at least $100,000 be minorities, women, or people in other disadvantaged groups. The complaint, which was brought by SEB Investment Management, was alleged that evidence that Wells Fargo was conducting fake interviews of diverse candidates simply to allow the company to claim compliance with the diverse search requirement. And the complaint was brought on behalf of shareholders who alleged that Wells Fargo had made misrepresentations. Ultimately, the Wells Fargo won dismissal of these claims last summer, and the judge, this is a California case, noted that while reasonable investors would not expect Wells Fargo to conduct interviews for jobs that had already been filled, shareholders failed to show that fake interviews were widespread or even took place at all. And there was no proof that the chief executive and two senior diversity executives should have known about in any sham interviews, or that Wells Fargo's years of costly scandals, including from the creation of fake customer accounts, should have put them on alert. And notably, Wells Fargo briefly paused their diverse slate programming during the advent of these allegations, but it has reinstated it. So while that is kind of just an aside, it is a good reminder of the real hard legal and litigation risk if a company did not take its obligations seriously. And then just to reinforce what you had already said, Christina, you want to consider whether to target all jobs or only certain jobs, right? Many companies focus on senior leadership roles or high-paying roles rather than their whole workforce. And you want to also consider instituting legitimate diversity in interview panels. If you have individuals who are diverse, if you're hiring for a marketing role, right, and you have women in the role and people of color in the role, consider putting them on those panels as opposed to having your applicants consistently be faced with, straight white men across the board. And then, like you said, we want to avoid tokenism. There have been numerous studies finding that if you only provide one minority candidate, say one woman in a pool of 10 men, or one Black woman in a pool of 10 white men or 10 white women, that the one candidate will not be hired. There's a Harvard Business Review article from 2016 that stated, if there's only one woman in your candidate pool, there is statistically no chance she'll be hired. So many companies are building out diversity slate programs for this very reason, right? To consider a higher percentage for diverse candidates, some as high as 50-50, to ensure, like the first example we showed, to ensure that a single candidate is not alone considered sufficient. Tokenizing one diverse candidate, according to the research, ensures they won't get selected. And so it's important to make sure that you're being intentional when you are trying to fulfill your diverse slate.
Yeah, I also like what you said about considering the diversity of the interview panels. And just with one note or asterisk too, is that the people on the panel should be obviously related to that person's role, so that it's not, oh, okay, we're going to get someone from a different organization that's really has a very limited connection to your role that you're interviewing for, but because they're diverse and we want to represent that we have diversity, we're going to put them on the interview panel, because then that's being disingenuous, which we probably all are aware of, but just wanted to note that as well. Another thing too to add is that even outside of the diverse slate, sometimes people are conducting their own interviews when they're, because of LinkedIn, right? So people can see who's at the company or who's left the company. So that's something that you can also work on in your respective organizations, just to like rethink the culture, because someone may not be on the interview panel, but a candidate may be reaching out to an employee that looks like them or has some relation to them, to ask them offline or off the interview panel about the culture there and what the experience could be like for them. And so you also want to make sure that you're fixing the problem internally to attract that talent, so they do apply an interview and they're not, opting out because they've heard things off the panel.
And as we're thinking about the diverse slate, one thing, it's not new from the Harvard and UNC decision, but we've been talking about for years, also thinking about, to the extent there's algorithm and AI, type use of review of resumes or things before we even get to an interview panel. And so being thoughtful about that, as I mentioned, we've been talking about for years. The EEOC, Charlotte Burroughs, has made it one of the priorities of the commission to focus on use of algorithms and kind of issues with potential discrimination with respect to the algorithms and weeding out certain candidates that never even make it to the interview panel. So just being thoughtful of that as we're talking about that. So that hasn't shifted and changed from the UNC and Harvard decisions, but just being mindful of that, because every day we're reading more and more about AI and what AI will be doing in the workplace. And as we see that proliferating and being used more, it's just to remain mindful of that. New York also implementing new requirements to now audit where there's the use of algorithms and being evaluated. And then I think we're going to see much more broader expansion of that, of really review, auditing, making sure that there's not issues that are taking place and it may be more passed down legally requiring it versus just done by companies internally. And so as we think about the risk and we think about the risk of diverse slate, it's just kind of a point of just interesting things that are going on. So we have seen since the UNC and Harvard decisions, as you're all aware, a rash of filings and charges and allegations against different DE&I programs. And America First Legal has been one of the large entities that is filing those charges with the EEOC. And that's led by a former member of the Trump administration, Stephen Miller. And that group, I think, I have in my notes dozens, but I think we're up to hundreds of the EEOC charges against different companies. The EEOC has not really particularly taken an interest with respect to investigating and pursuing those or pursuing commissioner charges or anything along those lines. But what we're seeing, for example, is one of these, the NFL, as many people may know, instituted the Rooney Rule back at the turn of the century and instituting this concept of diverse slates. And the league implemented that with the stated purpose of wanting to increase minority representation, racial and gender representation amongst coaching staff. And it expanded that role to include other senior operations roles and front office positions. And the NFL and the Rooney Rule was one of the focuses of this America First Legal Challenge in February. That group sent a request to the EEOC urging the EEOC to investigate the NFL and its member clubs over the use of the Rooney Rule. They argued that the Rooney Rule violated Title VII, specifically arguing that the rule has led to sham interviews and resulted in fewer opportunities for similarly situated, well-qualified candidates who are not minorities. And part of this has been supported by one of the commissioners, Andrea Lucas, right after the UNC and Harvard. She did write that she believed that decision, while could implicate a range of common employer DE&I initiatives, and specifically calling out, quote, selecting interviewees partially due to diverse candidate slate policies, end close quote. there's some discussion and some conflict amongst the commission, though. We also saw right after UNC and Harvard, we saw Chair Burrows issuing a comment and saying, no, this doesn't impact employment issues whatsoever under Title VII. The law remains the same as it has been. And so what we're seeing is just, it remains an unproven area of the law. You know, the Supreme Court decision certainly creates heightened risk of focusing on specific quotas of candidates, certainly, or suggesting it's a zero-sum game increases the risk. And so if there's some limited number of candidates who will be interviewed, or specifically setting a quota that it must be one of candidates versus having a goal or a broader kind of qualitative goal of a diverse slate, is certainly changing with respect to that risk profile. And so at a minimum, kind of the best practices and going forward is making sure that a different team is making the hiring decision from the team that is creating the applicant pool, ensuring that job descriptions are written neutrally, as Christina mentioned, and have EEO language in them. And really, at its crux and core, also considering an availability analysis, right? Defining in greater detail in our next topic, but thinking about what that pipeline is and what is available with respect to the broader pool of applicants possible in different kind of underrepresented groups. And so with that, unless anyone has anything to add to that, I think we'll move to our next topic. So moving to our next topic, we want to talk about publicly shared representation goals. We've seen companies do this over the years. So there was a big uptick with respect to the ESG movement and kind of the end of the teens and starting to publish stated goals that, for example, we want to see 50% of senior management by women by 2025, or we want to double the number of African Americans in our workforce by 2025. And a lot of companies have begun moving to stating such public disclosure representation goals. And so, Sarah, I want to bring you back in the conversation to talk with us a little bit about the risks of continuing to list those representation goals.
Yeah, absolutely. So particularly after 2020 and the racial reckoning during that period, we saw a ton of companies decide to publicly disclose explicit goals for their workforce diversity, e.g., we're going to have 50% of entry-level roles include minority candidates, and then defining those under certain protected characteristics. Or a lot of companies talk about doubling the number of Black employees. A lot of companies talk about doubling the number of women in senior management roles, and putting explicit kind of deadlines as well, saying we're going to do this by 2025 or by 2030. And that is an area of big risk. And it's because those start to look like quotas that are explicitly illegal both before and after the Supreme Court's decision, if in the context of employment decisions. And actually, Professor Hawkins really aligned with us very strongly on this, because this was the area she cited as the highest risk, right? Which is kind of explicit goal setting that appears to have race-conscious decision-making coming into play with hiring decisions. Now, the interesting thing about public goal setting, though, is it doesn't have to mean that. It can just say that we have recognized an imbalance in our workforce between who we hire and who is actually qualified and available to take on these jobs. And it can be presented in the manner that it's really about a remedial purpose to better match your population in your company with the population of qualified applicants. And to that end, it starts to mimic much more a voluntary affirmative action plan that is not only countenanced by Title VII, but is really a safe harbor under Title VII for these type of public goals. And that's where the kind of the double use of the phrase affirmative action becomes very confusing, because of course it means really different things in the context of a voluntary affirmative action plan under Title VII versus how the Supreme Court was referring to it in the context of college admissions. In college admissions, it explicitly meant the consideration of race in the selection decision, or the consideration of gender in the election, or the consideration of another protected characteristic in the selection decision. And in the context of an affirmative voluntary affirmative action plan, what it means is deliberate efforts to expand your applicant pool and your recruitment processes so that you're really looking at and considering all of the qualified candidates for the roles. And to that end, it is a safe harbor under Title VII and is much less risky than the idea of just explicit consideration of race in hiring. So what we're seeing is a lot of companies who made public goals, when we do a DEI audit, we say, are these goals tied to a really thoughtful applicant availability analysis? Did these goals come from a recognition that who you hire does not match the qualified applicants? And if the answer is no, we highly encourage companies to now do that study and check whether or not their publicly stated goals really do match what would be permissible under a voluntary affirmative action. Goals basically should match availability. There is a big risk in saying we're going to double the number of women in our entry-level class if there really isn't room within the applicant pool to do so, such that it doesn't really match availability. And the concern there is when you are not matching availability, one, you likely don't have the safe harbor under Title VII, but more so than that, it starts to look more like a quota, a sex-conscious decision-making, than it does to look like a goal set to remediate the discriminatory imbalance that exists in your application process. So it becomes a higher target and risk area if these goals are really untethered to a study of the applicant pool. And what's interesting about the Title VII safe harbor position that we've found is that there is not an explicit definition necessarily of exactly how to define your applicant pool. And we've had clients that have defined it nationwide, where that best matched the reality of where they were willing to pull people from. We've had clients focus on the top 10 schools they tend to recruit from. And I will say being thoughtful about how you define your applicant pool can really allow you the opportunity to better match kind of the public goal setting that you'd like to state. But at a minimum, we are telling people, look at what you're saying publicly and take a moment to reflect. Did that reflect like a proper analysis? And the final question on the slide is, should we be using the same concepts when building out a diverse slate approach? And the answer is yes, right? If you're requiring a certain percentage of candidates to be considered in a diverse slate approach, it will be a much easier to defend that if that matches the availability of qualified applicants.
And so as we monitor our time and have 7 minutes left, we wanted to bring in a quick hypo here. Really, it's kind of what I set up at the beginning. So we have a company that stated something with respect to a public commitment that 40% of entry-level employees will be female and doubling representation of Black employees by 2025. And so as a company stated that 4 years ago, we're ready now, a year out from 2025, to publish our annual update on the progress towards those goals. As a company, what are companies doing? Are they changing the approach? Are they disbanding what they set out as goals previously? What are companies facing?
Yeah, so companies are doing that audit to make sure that the publicly stated goals match to or tethered to some type of actual availability analysis. And many are starting to really consider doing voluntary affirmative action plans to provide themselves with more protection. But we couple this advice with the concern, particularly for publicly traded companies, that stopping your efforts, massively pulling back, or not providing updates or disclosure to shareholders about the status of long listed public goals could create a separate type of shareholder risk. Basically, the concept of greenwashing has been applied to diversity washing as well. And the SEC is looking into instances where companies have maybe stated that they make, this is similar to the Wells Fargo case we described earlier, which of course Wells Fargo won, but this concern, the companies are publicly stating they're doing so much and then secretly have completely disbanded those programs or pulled them back or conducting sham interviews. So there has to be, particularly for publicly traded companies, a real caution when making a determination to stop heading towards a publicly stated goal you've been making since 2020. But we do suggest some thoughtful behind the scenes privilege studies related to how to tie this appropriately to your applicant pool to justify the public numbers that you've disclosed.
And as we think about all of this, right, it comes down to being thoughtful and being creative, and kind of as we finish what we have to talk about, kind of thinking about that it's not pulling away from these programs, being thoughtful, because as we've talked about, it's facing shareholder derivative actions on both sides, right? Challenges with respect to pulling back from previously stated initiatives, or we've now focused on something improper for the company that's pulling away from profits or expectations of the company, and that's not the goal of the company. And so that challenge, that tension, I think it's just the new paradigm in which companies are operating. And so we just need to be thoughtful and creative as we move forward. And so that kind of takes us to our final of what we've been talking about is analyses, audits, how we set up the crux of this. And as an employment litigator, my favorite, record keeping and documents and information, because I always just want evidence. And so kind of as we shift to this, Lindsay, I want to bring in just to kind of talk about logistics, including record keeping and training, and kind of what we see as best practices there as we wind up our presentation here.
Yeah, so we want to leave you guys with just some, high level, what's permissible, what you should not be doing as we move forward and try and ensure that we all have diverse workplaces. So, right, it should be clear, can you consider the person's race? No, you can't in employment, but you can consider the person's leadership in an affinity group in college or their prior or a prior employer. Can you consider only female candidates for a role marketing a product to a mostly female audience? No, but you should consider candidates who have primarily worked in marketing products to female audiences. It's important to understand, right? At the end of the day, we want diverse workplaces, but we want workplaces that work, right? We want to make sure that our companies are succeeding, and that means hiring the people who are most qualified for the role. And those two things are not those two things are not opposed to one another. But it is important, looking at it from the perspective of a litigator, like Ryan said, it is always, I can talk about it in real time, right? Like, it is always helpful to have records explaining why you hired someone, right? You never know, and for any reason, why, if someone's going to challenge the basis of a hiring decision or a salary decision, right? So it's important to keep those types of records. It's important to train your HR team, right? The recruiters, the interviewers, the hiring managers, making sure that they understand what's permissible and what's not permissible, why we want diverse experiences and ideas, and making sure that they're understanding that it's about considering diversity of experience, leadership resilience, commitment to diversity, all things that we would hope that companies are welcoming with open arms. And I know we only have a minute left, but Christine, I just wanted to kick it to you to see if you also have any words on final best practice considerations.
Yeah, thanks, Lindsay. I also echo everything you've said, and I also would recommend considering standardizing the interview questions. There's a company called Greenhouse that some organizations use. Again, it comes with the training, though, because as a litigator, there are certain things we don't want in writing. However, this program, trains people on how to interview and what type of feedback you should put in within 24 hours, because some interview processes could take a long time. And so when it comes down to deciding who you want to pick from the pool, you've forgotten. And so I think that kind of removes some of the bias if you're targeting what you put in. And then just generally doing a privileged audit of your, employee hotline and seeing what are the issues in your organization, because, as we're talking about hiring, we want to make sure that employees are staying and that employees are being promoted, and it's not just getting them into the organization. So making sure that you're addressing issues internally will also help with your hiring and your promotion, and also standardizing your internal promotion processes too. So it's not a, tap on the shoulder, but there's more of a standard process with that too. So those would be my additions. Thanks.
Great. Thanks, Christina. And at this point, we must conclude this session. On behalf of our chapter, I'd like to extend a special thanks to Paul Hastings and to our panelists, Ryan, Sarah, Lindsay, and Christina. We'll be taking another break. However, if you have a question for or would like to speak with any of the panelists directly, feel free to take yourself off of mute and address the panelists while we're on break. And thank you so much, and we'll meet back here at 11:05.
Welcome back from break. My name is Terrell DeJean, and I'm Senior Counsel and Senior Manager at Capital One, where I work in corporate and strategic transactions. I'm also co-chair of the ACC NCR DEI Programming Subcommittee. Before we transition to our last session of the day, we have a special spotlight. Otsuka Pharmaceuticals received the In-House Innovator Award at our ACC NCR Corporate Council Awards in 2021 for its Diversity Accelerator. We have a short video to share that will highlight Otsuka's accomplishments and impressive DE&I platform, which we hope will inspire each of you to consider how your department can have a greater impact.
At Otsuka, our purpose is to defy limitation so that others can too. And when you work in a highly regulated industry like pharmaceuticals and have such a lofty purpose and goal, we realize that we need diversity of experience, diversity of thought, diversity of opinion in order to handle the complex and dynamic legal issues that are presented to us.
Hi, I'm Karen Galley. I'm General Counsel at Otsuka Pharmaceuticals. And Otsuka has really offered us many opportunities for our department to embrace diversity, equity, and inclusion. First of all, a member of our department, Sabrina Mays Jiang, was on a rotation and was our first DE&I officer, and she founded the DE&I office at Otsuka. We also are involved in our employee ERGs, employee resource groups. A member of our department, Jacqueline, is the employee co-lead of Inspiration, our Asian Pacific Employee ERG, and I'm a co-executive sponsor of Otsuka Hope, the ERG for our LGBTQ employees and allies. We also are a Mansfield Rule certified department. We joined the Mansfield Rule, which is a program run by the Diversity Lab, many years ago, and have completed the first cohort and are now enrolled in our second cohort. It's an ongoing process to maintain your certification. And one interesting fact about that is that one of the criteria for the Mansfield Rule, as many of you know, is to have diverse candidate interview slates. And that actually became a corporate goal for Otsuka last year in 2023, that we applied a metric to have a diverse slate of candidates for open roles. So it's interesting to see the application of things that we've learned through legal affairs and participation in the Mansfield Rule then applied to the greater organization. Another way that we support diversity, equity, inclusion is to be corporate members of legal groups that are focused on those areas, such as LCLD. And finally, we offer a diversity secondment for traditionally underrepresented groups, attorneys of those groups who are working at law firms to come and be secundees at Otsuka, either part-time or full-time, for roughly 4 to 6 months. And that offers those attorneys an opportunity to really live the life of their clients and to understand their clients' mindset and the pressures that we face and the challenges that we face. And then in return, the law firms that we work with offer those attorneys a promised benefit is for their participation in this program. So either a seat in a leadership development course or contact with mentors in other offices to increase their network within the film. But it's all in an intention to get that attorney on a level playing field when they're furthering their career at the law firm and potentially in the future up for partner. And it's been a really great benefit for us because we get well-trained attorneys, high-performing attorneys who can really produce good work for us while they're here, and they're at the same time learning, what their client's lifestyle is or work style is. One reason that I'm so intentional about having a diverse department and focusing on diversity is because I really view the problems that we face are so complex and require diversity of experience, diversity of background, diversity of thought to really get to the best solution, that I view that it would really be, dereliction of my job to not have that diversity in my department to help solve those complex problems. And I really feel that it's produced a valuable result, the best result for the company is to have a diverse legal affairs department. So thank you for listening about what Otsuka has done to embrace diversity, equity, and inclusion. And I hope that you can take some of these things and apply them in your law departments. And if you have great ideas, I'd love to hear them from you.
I'm delighted to introduce you to the work of the Leadership Council on Legal Diversity, a fast-growing national organization dedicated to building a more diverse and inclusive legal profession. The idea behind LCLD is simple but powerful. To create a future generation of diverse leaders in the profession, we must first mobilize the top leaders of today. That is why, since our founding in 2009, LCLD's membership has been made up of the General Counsel of major corporations and managing partners of the nation's leading law firms who work in collaboration to achieve our goal. Each of these individuals has made a personal commitment to the defining mission of our organization. In joining LCLD, they've also committed their organizations and the lawyers who work there to pursue that goal alongside them. Shortly after LCLD was launched, we began building programs to help minority and female attorneys expand their professional horizons. In the years since, more than 10,000 talented individuals have benefited from the professional development offered by our mentoring, 1L Scholars, Pathfinder, Fellows, and alumni programs. Today, LCLD program graduates make up one of the most powerful networks for the next generation of leaders in the profession. And by producing tangible results in the lives of these talented individuals, we work to promote inclusiveness in our professions, our circles of influence, and our society. We continue to make progress toward fulfilling our mission to make the U.S. legal profession as diverse as the nation it serves. Please join us on this journey.
Hi, my name is Layla Hawk, and I am the Director of Legal Department Partnerships and Inclusion Initiatives at Diversity Lab. At Diversity Lab, our mission is to test out and incubate innovative ideas to increase the diversity of the legal profession. We do this by applying behavioral science, research, and collecting data on all of our initiatives to evaluate their effectiveness and make them more effective as time goes on. We work quite primarily with legal departments and law firms, and we do that in a few ways. First is helping those organizations diversify their teams internally. Many people have heard of us through the Mansfield Rule. That's one of the #1 ways that we work with law firms and legal departments. The second is we work with legal departments to help them evaluate and partner with their outside counsel teams to increase the diversity of those teams working on their matters. And then finally, we help legal departments and law firms partner together to increase the diversity of the legal industry as a whole. We work with organizations in a number of different ways, unique to every organization. So just reach out if you have any questions about how to work with us.
Now it is time to move to our last session of the day. We are pleased that our platinum sponsor, Kroll & Waring, will join us for a discussion on considering DEI in employee development, advancement, processes, and supplier programs post-Harvard. As a reminder, if you have a question during this session, please use the chat box at the bottom of your screen. The panel will address your questions as time permits. Once again, All remarks made by today's panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC NCR. And now it is my pleasure to introduce our panel for the final presentation for the day. Ellen Dwyer is a partner at Kroll & Moran. Corporate boards and client leaders trust Ellen to advise them in the most sensitive employment matters that generate significant risk for their organizations. Whether leading a high-profile sexual harassment investigation, litigating racial or gender equity issues, responding to activist shareholder demands, or advising on the myriad issues that impact her clients' most productive talent, Ellen serves as a strategist and collaborative partner to her clients. Chris Mead is also a partner at Kroll. Chris has decades of experience as a trusted advisor to leading multinational corporations and is a highly regarded labor and employment thought leader. Compliance with employment laws and regulations is always a challenge, particularly when an employer's workforce is highly skilled, mobile, and innovation-focused. With an emphasis on technology, consulting, healthcare, and other information-driven industries, Chris works with boards of directors and senior corporate leadership to achieve their business goals through development of effective strategies focused on critical areas, including pay equity, the use of artificial intelligence and machine learning in making employment decisions, racial equity and civil rights audits, and retention of top talent. Luisa Lopez is an experienced in-house attorney with a specialty in labor and employment law. She works for National Geographic Society as Vice President and Senior Associate General Counsel. In this role, she leads the Society's global employment law function and ethics program and serves as a strategic partner to the Society's HR and diversity, equity, and inclusion teams. Prior to joining National Geographic, Luisa held senior in-house roles in the digital media and technology industry and also practiced law as an attorney in the Washington, D.C. office of Venable, LLP. Luisa is a member of the ACC NCR Employment and Labor Committee. With that, let's begin.
Great. Thank you so much for the kind introductions and good morning, everyone. I'm Chris Mead, and we'll launch into our panel here. I will kick us off here by briefly running through the agenda that we have for today's meeting. First of all, Ellen will lead a discussion of employment programs that are designed to ensure that employers are retaining and developing their talent. Many employers have, over the years, established mentorship programs, sponsorship programs, and other types of programs targeted specifically for women or members of racial subgroups. Many of these programs were implemented based on a recognition that men, and white men in particular, often benefit from informal mentoring and sponsorship programs. So Ellen will walk us through the legal framework that relates to such programs and some of the recent attacks on those programs. She will also tee up the potential impact from last week's Supreme Court decision in the Muldrow case, which is tremendously important in this realm. Ellen will then toss the mic back to me for a discussion of supplier diversity programs and investment programs. We certainly saw a huge expansion of those programs following the George Floyd murder in 2020, as many employers, out of concern for their communities, took steps to try to provide greater opportunities to minority-owned and women-owned businesses and to expand their supply chains. We will discuss the framework that is provided by Section 1981 for assessing the legality of those programs, and we'll also look at the litigation challenges that exist in that realm. We will end with another discussion of an increasingly common practice, which is enhancing accountability for progress on DE&I initiatives by tying executive pay in some way to such initiatives and progress on such initiatives. All along the way, we will try to pause and provide some practical tips for navigating the challenges we see before us. And Louisa, in particular, will be illuminating the discussion by sharing what not just NGS, but others have done in these realms. So please do ask questions as we go. We will try to field them in real time to the extent that we can, but we will certainly answer all the questions one way or another. With that, I will also say that we're going to use some polling devices as we go along the path here. I hope folks are familiar with this. The idea here is that we will ask questions. Here are the first two that we've teed up. We would love to get maximum participation here. The idea being, with regard to these first couple of questions, we'd love to hear the extent to which your DE&I programs include mentorship programs, sponsorship programs, or differentiated development programs. By differentiated development programs, we're really referring here to programs for which employers have traditionally made selections based, at least in part, on the race or gender of the employees. These are certainly types of programs that are in the spotlight now. They can include leadership development programs and other types of programs. And then the second question asks whether you modified in any way those programs. So here's our response. Thank you, Kasha. It looks like more than half of our participants today have such programs, and it looks like about a third or so have modified them in some way. So with that as the backdrop, why don't I turn the microphone over to Ellen, and we'll keep rolling.
Sounds great. Thanks, Chris. And let's go ahead and go to the next slide. And so I just want to, not that back one, sorry, I took you too quickly. I also just want to say good morning and thanks for having us. And it's great to join Louisa and Chris here. And I do have like this yellow lab that's kind of in the background, so hopefully you won't hear her. But she's just part of my family here. So just jumping in, Chris sort of gave an overview here of the kinds of programs that we'll focus on. Louisa and I will be taking turns here as we talk about the programs. But really, I think these programs, like historically, have not drawn the same level of attention as some of the hiring practices, promotional practices, and otherwise, right? As different organizations and actually, individuals have brought claims largely under Title VII, challenging race-based actions. And so when we were putting this program together, we were really working hard to ensure that you all would meet your CLE credit by us being able to provide enough content here in this space, because there really just has not been significant litigation so far. And I think as we get into a discussion about Muldrow, I think that that's going to change, but not too much on the legal front at this point. But we sort of moved to the question of, so who has and who do we expect to be challenging these programs going forward? And not all of the challenges, of course, have been through the initiation of litigation. I want to give you a little bit of sense of who some of the key players have been. They may be well known to you, depending on your experience with them so far. But the first here is America First Legal, and that is an organization. It's a nonprofit conservative organization that's headed by Stephen Miller, who's a former advisor to former President Trump. America First, at least as they say on their website, to this point has launched 100 different legal actions challenging race-based policies and practices for private employers. They've done that in a number of ways. They've issued several press releases. Some of you may have received those and seen those releases. They've written letters to boards of directors. And again, many of you have received, I'm sure, some of those letters. Largely, the letters are accusing employers of having unlawful DEI programs, often accused of mismanagement, but discrimination against non-majority, majority employees. They've also written several communications to the EEOC, seeking the issuance both of commissioner charges and just the launch of investigations, identifying particular employers who they believe have practices that are unlawful under Title VII. There's also, of course, this organization is more familiar to many of us, the Students for Fair Admissions. Edward Blum is the president of that organization. It's interesting, the stated purpose of SFFA is to, and I'm quoting here, to defend human and civil rights secured by law. Edward Blum has been active, and I expect will continue to be as well. And the third organization is the National Center for Public Policy Research. Again, is a nonprofit organization, conservative organization, which again has launched various litigation matters. And the one I've highlighted here, which we'll be talking more about, is the Starbucks litigation matter, which is a shareholder derivative suit. So with that, why don't we go to the next slide? So others who have challenged race-based initiative, of course, include state legislatures. And as you can see here on this slide, there's at least 9 states that have passed laws restricting DEI programs, and we've identified several of them here. Utah is sort of an interesting example of this, in part because there's a HB 261, which prohibits certain DEI policies and procedures and practices, largely in the public education and university space. But it's interesting, there's another law, which is Utah. It's not actually a law at this point, it's just a bill, Utah HB 111, which is interesting because it would have been the first state law to reach private employers and extend the DEI restrictions to workplace training programs. It would prohibit unconscious bias training programs in the private employment context. It was introduced in early 2024, but ultimately was not enacted. So that's really the sort of closest brush that many of us have had as private employers with some of the legislative actions that are impacting much more directly public employers, and in particular, as I said, in the public education space. Another group that's been challenging some of the race-based initiatives, of course, are the state attorneys general. There are many AGs that have been active in this space, and there's 13 in particular. Most of them are southern states that have been challenging the race-based initiatives, and in particular targeting, and by name, a number of different companies. JP Morgan's an example, Goldman Sachs, and others, with the goal of challenging and bringing to an end the racial preferences in hiring in particular. It's sort of interesting, and we'll get into this a bit more, but whether it's some of these nonprofit organizations or state AGs, they're getting most of the information that they have about private employers' practices really off of the public websites. So it's been a low cost effort in some respects from their perspective. Many of the organizations that we're citing in these slides, and many of the organizations that Chris and I do work with, are quite proud of their DEI efforts. And so they're issuing DEI reports. They are posting on their websites, the various practices. So it's not hard to find, as we see, and as we move through these slides. Chris, you want to move to the next slide? So in this slide, we're really just, and I think this was clear from the beginning, but to emphasize it, the legal theories of challenge here, really it's sort of, we're focused on Title VII principally. So as we look at mentorship programs, sponsorship programs, the focus here is 42 USC 2000E-2D, which is, is there discrimination? Are there racial preferences that relate to training programs or mentorship programs? Are individuals being excluded from those programs based on their race, or are some of these programs, right, overly inclusive of minority organizations? So it actually can work both ways. In terms of legal theories and potential statutory, anti-discrimination laws and provisions, a number of these beyond Title VII itself, there's greater protection that is afforded by some of the state non-discrimination laws. And in this slide 6, we're just providing a couple of examples. Here's the California Fair Employment and Housing Act, and then we also have the DC Human Rights Act. These state anti-discrimination laws, of course, extend protections well beyond race. So when you look at the DC law in particular, there's, protected characteristics include sexual orientation, gender identity or expression, a whole range of different protected characteristics, and the same for the California law as well. You want to go to the next slide, Chris? So we've identified some of the statutory bases for claims here, and it was interesting just to look, and I'm reaching a little bit because, as I said at the outset, there's not much law as it relates to mentorship and sponsorship programs. But one of the theories that we were interested in looking at relates to shareholder derivative claims or fiduciary breach claims. And so we pulled out these in particular, this, and we've already mentioned the Starbucks case, but the National Center for Public Policy Research, one of the organizations that we identified. In this case, which was decided on a motion to dismiss, the court in the Eastern District of Washington dismissed this complaint. And it's very interesting. I mean, it was the plaintiffs here were largely challenging in sort of sweeping terms, Starbucks, DEI, a number of their DEI initiatives, which were all prominently displayed on their website. One of them that I've just highlighted here was there was a reference to Starbucks Leadership Accelerator Program that targeted minority employees in particular to help them build relationships with, to gain visibility with the leadership pipeline, sort of more senior leaders at Starbucks. The case was dismissed pretty handily. If you haven't read the decision, it's very interesting to read. It didn't get into any substantive discussion of the accelerator program, much to my disappointment. But in September of 2023, the court really gave the complaint the back of his hand. And both this case and then the Disney case really were just decided based on sort of affirming the business judgment rule, affirming the discretion that is afforded to management of companies to make decisions about management, what this court was characterizing, right, as a management decision. The court said some really interesting, remarkable things, including, I've got one of the quotes here, that the quote, plaintiff did not file this action to enforce the interests of Starbucks, but to advance its own political and public policy agendas. So the court was not particularly patient The plaintiff here owned, as it turned out, like 56 shares of Starbucks stock out of more than 1 billion shares that exist. And that certainly had an impact on the courts. The judge cited that. But really found that the court refused to and said it had no business involving itself in reasonable and legal decisions made by the boards of directors of companies. And so it'll be interesting to see to what extent some of these nonprofits continue to pursue this approach through shareholder derivative claims. And similarly, we don't really need to spend time on the Disney case, that Delaware case from 2022. But again, it's just a variation on the theme. They're alleging, that officers and directors of Disney had breached their fiduciary duties by expressing public opposition to Florida's Don't Say Gay bill. So in both instances, I think certainly employers came away from both of those cases, those decisions, feeling emboldened, right? That at least they weren't going to have to, at least to this point anyway, they weren't going to have to litigate what are extraordinarily expensive claims in the derivative context. So Chris, let's go to the next slide. So just as it relates to Chris sort of in the intro talked a bit about mentorship and sponsorship programs, and it sounds as if, right, many of the folks who are with us today do have such programs. I think that, the point to note here is, so, what risk do these programs present? It really is the issue to focus on is sort of what is the selection criteria for membership in or participation in a mentorship or sponsorship program. And of course, the challenge comes from identifying race or gender, ethnicity, or another protected characteristic as the basis for participation. So, for example, if you have a sponsorship program, and many employers do, which I will say from personal experience, they're really powerful programs that can, in some cases, give employees access to relationships, to opportunities that they may not otherwise have. And I think many employers proudly declared that they would focus their mentorship and sponsorship programs on either racial, ethnic, diverse employees, women. And as Chris said at the outset, really with the underlying assumption that women and racial minorities have not historically in corporate America they haven't had the same access to some of the influential relationships that white men have had. And so with that sort of in mind, a number of these programs were born. And quite explicitly, as I think employers were forming up the programs and participants, really being quite intentional about ensuring that they were including either in proportion or disproportionately racial and ethnic minorities and women. So that's sort of a little bit of the genesis of where they came from. We really do camp on, and the issue to be mindful of is whether you're taking into account race-based distinctions in forming these programs and in populating the programs, which can be quite powerful experiences for employees. I, again, identify below here, this is what I mentioned before, the Leadership Accelerator program that Starbucks has. That again, at least based on public information, Starbucks limited that program to BIPOC partners. So really with a focus on Black and other minority employees. And again, in the litigation, the allegation was that it was discriminating against white and Asian employees of certain employment opportunities because they weren't in the program. Again, based on the decision that I just referenced, right? We didn't get into that. That issue wasn't litigated, but I think it's an issue particularly now that we have the Muldrow decision out there. I think we'll be learning more about what the courts think about these programs, and we'll talk about why. So next slide, Chris. So affinity groups and ERGs, and Luis is going to chime in here, I think a bit on this one. The question, again, many organizations, many employers have these affinity groups. In some cases, employers have restricted membership to, if it's an African-American affinity group, right? In some cases, it's just available to African-American employees. And there's an interesting issue, and again, Louisa may weigh in on this, but when you think about for members of these affinity groups, in some cases the members would prefer that the affinity group is not open, right? That it's not available to, in the case of an African American affinity group, right? They're not looking to have participants from white employees or Asian employees or others, right? There's some benefit that they find by bringing folks who may be having a common experience or a common identity together. And so I think a number of employers, of course, are navigating that issue today. Should it be open? Should it be restricted? But in many cases, the affinity group is formed around a racial or ethnic identity. And then there's the question, of course, which is if an employer is providing financial or other support to a race-based organization or group, does that have the potential to violate Title VII or other, state, a companion state law? Again, a potential risk for us. I reference here the Hasbro example. This is sort of interesting. Hasbro, of course, has been a target of a number of the nonprofits that we talked about, both in terms of like writing to Hasbro. I don't know if we have anyone from Hasbro with us. You can chime in the chat. Not great to be a target of these things, of course. But with allegations as to their robust DEI programs together. But in this particular case, one of the areas of attack was that Hasbro had joined actually an organization, the Black Young Professional Network Partnership, which is not limited to Hasbro. Hasbro just created an opportunity for its diverse employees to participate in what was a national organization. And again, that was called out by one of the nonprofit organizations, both in a press release and in a letter to Hasbro, and in a letter to the EEOC complaining that this was a DEI initiative that was unlawful under Title VII because it was discriminating on the basis of race in this particular case. Really the only case that I could find here, and it's sort of sad, and I mean, citing to you a New Jersey Superior Court case isn't really sort of Supreme Court level, but we were pretty desperately looking for cases where, mentorship or sponsorship programs were under attack, or affinity groups, ERGs, just looking for anything at all. And this is just a reference to a somewhat recent decision from New Jersey. It's March of this year. And I would say if you read this case, it's not sort of on all four squares here, even really identifying the core issue. There's just a reference to the fact that a white employee had claimed in trying to make out her own discrimination claim that this employer had an African-American affinity group, and she was citing that as evidence of the fact that this employer discriminated against white employees. And the court pretty handily dismissed that argument. Again, it's not sort of the basis for the decision, but it was useful language to see how the court was thinking about that sort of argument. Go ahead, Louisa.
To chime in, I think really the key is how we communicate these opportunities. And I think it really helps to have governance framework and operating principles where your organization can really establish pillars for these affinity groups, employee resource groups. We call ours inclusion networks, and just really ensure that those pillars then align with your organization's direction and overall DEI strategy. And to ensure that not anyone can just form an affinity group, that there are some governance in place to establish formal recognition through a process. And that way we can ensure that these employee resource groups have a clear purpose statement that articulates the group's goals. And then, ideally that goal then aligns with your framework and strategy. So I think, those operating principles and framework that's ideally managed and implemented by your DEI teams can really help set and communicate what these opportunities are for, what the goals are. And I think that can mitigate concerns about the concern that they are exclusive, right? Because I think to Ellen's point about open membership, obviously we reduce legal risk if they are open. And I think that is more in line with the goal of a more inclusive workplace to foster belonging, providing safe spaces for connection, empathy, discussion, and development. I think raising awareness. But I think at the time when we think about open membership and that's more inclusive, I think we have to balance that with the practical expectation that these groups are intended to provide a safe space for employees who share a shared identity. And while allies and supporters are welcome, they're not the primary audience for these groups. So I think that's just a practical consideration, even when we set broader parameters for how we define these groups, like in terms of interests and goals, something to consider.
That sounds great. And Chris, let's go ahead and jump because I'm looking at the clock and I'm behind. So let's go. I wanted to just highlight, right? I've referred a little bit to Muldrow, and hopefully folks have seen and had an opportunity to read this decision, but it's a unanimous Supreme Court decision, came out not long ago, just days at this point. And the case came out, arose in the context of a job transfer decision. And so one might think, well, what does that have to do with mentorship and sponsorship programs? But really, it's quite an important decision. And Muldrow, and I've included some of the facts here, related to a police officer who claimed that her transfer to out of actually a special sort of intelligence division was discriminatory. And the quick facts were, no change in title, no change in compensation or benefits. And in many jurisdictions, that would have been the beginning and end of it, right? And it was in the lower court that she hadn't been able to demonstrate under Title VII that she had suffered a significant harm. But the Supreme Court had rejected that standard, overturned really decades of lower court decisions applying a significant harm standard, and said in order to prevail on a Title VII claim, that the plaintiff must do two things. One, must show some harm relating to an identifiable term or condition of employment, but noting that harm doesn't need to be a significant harm. And you can imagine lots of debate about what this will be going forward. And then the other is, of course, that the employer acted for discriminatory reasons. And in this case, the plaintiff alleged that she was transferred because of her gender. So let's go to the next slide. So I think what's most interesting really about Muldrow, and there's been a lot written about this already, and if you go look at some of the nonprofit organizations I identified at the beginning, there's a lot of activity on already trying to go after some of the programs that really haven't been litigated in the past, but citing Muldrow for it. So the issue is now sort of with that decision can and will plaintiffs challenge sponsorship programs or mentorship programs or affinity groups, other sorts of programs that we've been talking about here, because they are race-based or based on gender or another protected characteristic. And certainly the bar has been lowered. As Justice Kavanaugh said, it's a relatively low bar at this point. Showing that you were excluded from an opportunity because of your race or your gender is sufficient, right? Will be sufficient. And I thought it was interesting in his concurrence, which I reference here, in talking about like what might be sufficient harm, some harm. He references, missing out on networking opportunities or professional relationships, which is very much goes to the heart of what some of the sponsorship and mentorship programs have been. So I think if we were to do this in a year from now, there'd probably be a lot more to talk about with sponsorship and mentorship programs in terms of litigation, because I think we're going to see a lot more activity on that front. I'm going to go to the next slide, Chris. So just some highlighting of practical tips here quickly. And Louisa, I want you to chime in because you're going to have very good thoughts. But, and Louisa's already mentioned this, right? One way to mitigate risk is to open the membership of your affinity groups to all employees, irrespective of the race, gender, or whatever other attribute is that the affinity group has come together around. And the selection criteria, which is really the key here, when you're thinking about sponsorship and mentorship and differentiated development programs, ensuring that selection for those programs is not based solely on race, gender, or another protected characteristic. Thinking broadly about diversity, right? If we're wanting to include diverse individuals in these programs alongside majority employees, thinking about defining it broadly. Socioeconomic status, first gen, other things, sort of the non-race-based characteristics, and being really careful in that regard, right? You can't, in the name of socioeconomic, just use that as sort of a substitute for race, right? You really want to have some variability there. Think about employee performance, right? Many employers have high potential programs, which is based on the performance of the employee, again, not based on the race. And why don't we go to the next slide? But Lisa, I want to just stop if I can and let you chime in here.
Yeah, I'll just add, like, I think the theme of the conference today in terms of these mentorship development programs is that until recently, we've gotten comfortable that these minority-focused efforts were pretty low risk, that they were not likely to constitute adverse actions. They're not linked to hiring decisions, promotion decisions, or compensation decisions, and really contribute to pipeline building, whether that's recruitment pipeline or leadership pipeline, where the focus is more on professional development or growth, expanding networks, or even diversifying professional networks. So we've gotten comfortable, and I think, as Ellen mentioned with Muldrow, that might change. So as a practical tip, I think it's a good time to check in, right, and find out who within your organization manages these types of programs and might need updated guidance. It's good to find out, who's designing the program rubrics and establishing the eligibility criteria, engaging with managers on a nomination process, and then making selection decisions. And then who's communicating about your programs? We're often really excited to promote and share what we're doing. And we share communications internally, externally through press releases, posting application materials, FAQs, and these are public-facing materials, that unfortunately are being weaponized by some of these political advocacy groups that we're covering. So yeah, I think really it's more kind of that odd time for a check-in internally.
Yeah. Okay, great. So I'm going to leave you with this last slide, which I'm not going to get into. Chris and I have debated this issue, sort of the viability of the Webster and Johnson line of cases in the wake of the Muldrow decision and the SFFA. And those cases are, of course, about affirmative action plans. And you can read them at your leisure here, but I want to get to, Chris got a lot of ground to cover. But they're interesting, and I think it really is an open question as to whether voluntary affirmative action plans how they will fare in light of the recent Supreme Court decision. So I'm going to stop there. Let's go to Chris. You're going to go to your next slide and lead us through a discussion about supplier diversity and investment programs.
Thank you, Ellen. Thank you, Louisa. We do have polling questions again. We're going to shift over to supplier diversity programs next. And here we're talking about these, the programs where we extend a vendor program and we have, in some cases, preferred providers. We see any number of approaches to supplier diversity programs as we've been assessing them with our clients. Some of them are programs whereby employers are talking about expanding the pie in such a way that not only would diverse suppliers have more opportunity, but non-diverse suppliers as well. There are others who target a specific percentage of their supplier spend or a certain dollar amount that may not necessarily be tied to expanding the pie. So any number of different types of approaches out there. Our polling questions are coming back now. Thank you, Kasha. Looks like about 70% of us do have supplier diversity programs. Only a few have modified them since the Harvard UNC decision. And then if we can see the response to the third of the three questions, maybe we can't. Anyway, we can move on from there. The idea, and let me just close this out. There we go. All righty. I'm trying to navigate here. As we mentioned from the outset, there has been a real, I think, maturation of supplier diversity programs since 2020 and going forward. We could start with the obvious here, which is that supplier diversity programs are not employment programs. So they're not designed with employee development in mind, but they are certainly important pieces of overall DE&I programs, and they can certainly be important to employee satisfaction, retention, beliefs by your workforce that you as an organization are quite committed to improving communities. These programs did grow out of, I think, a real desire by corporate entities to support the communities in which they operate, in which their products are sold. It was a way by which many organizations thought they could have a real influence on not their workforce necessarily, but on the society in which we operate. So very high, lofty goals behind these programs. As I mentioned before, there are various attributes of supplier diversity programs. We've seen some where there are scorecards used by the employers, where to the extent that a vendor may be woman-owned or minority-owned, you get extra points in the solicitation process. There are others that simply focus on trying to, again, grow the pie and ensure that there are more diverse suppliers in the program. The legal framework that we're operating under here is Section 1981 of the Civil Rights Act of 1866. So it's a different approach than Title VII, but has some parallels, certainly. As folks know, Section 1981 was enacted after the end of slavery as one way to try to ensure that the racial effects of slavery were not perpetuated through exclusionary contracting practices. And so for 100 years or so, this statute was relied upon by people of color to assert claims against those who were denying them contracting opportunities based on their race. In 1976, the Supreme Court made it clear that in the McDonald case that this avenue was available to white persons as well. So we have seen cases for about the last 50 years or so that can raise claims on behalf of Caucasians, asserting that they're being discriminated against under Section 1981 as well. There are two other important pieces to the puzzle that we'll spend just a minute on here. The first is that only disparate treatment claims are available under Section 1981. So your defenses to 1981 claims can be quite a bit different from your defenses to Title VII claims. And then secondly, and most importantly, is the but-for causation standard. In the Comcast case from 2020, the court made it very clear that the plaintiff must show but-for causation to prevail under Section 1981. In the context of supplier diversity programs, what that means is the plaintiff has to show that the plaintiff would have won that contract opportunity or been able to participate in that contract opportunity if it weren't for the race of the owners of the organization or the individual who's asserting the challenge. Obviously, in this space, we see claims coming not from employees, but from non-employees as well. Now, up to date, the action. There are a couple of cases that have gotten a fair bit of play in the last 18 months or so, about 2 years, in terms of the filings. The first is brought to us again by America First Legal Foundation. They represent Christy Boldak. In this case, filed against Amazon. Christy was a white woman from Texas who alleged that she wanted to be an Amazon delivery service partner, but was discouraged from doing so because she was not eligible for a $10,000 grant that was provided by Amazon to others. In the lawsuit, America First alleges that the grant program run by Amazon, pursuant to which African American, Latinx, or Native American delivery service partners could obtain a $10,000 grant to build their business, violates Section 1981. As of 2 days ago, this slide read, case still pending. Yesterday, the court in this case actually issued a decision. Amazon had filed a motion to dismiss on 2 grounds, the first being standing, and the second being failure to state a claim under Section 1981. The court disposed of this case on the motion to dismiss yesterday, finding that the plaintiff did not have standing, largely because the plaintiff did not show that she had been injured by this program. Importantly there, she had not applied to be a delivery service partner. She simply alleged that she was discouraged from doing so because she was not eligible for this $10,000 grant. So while it's nice to get a decision that supports the employer in this case, the Section 1981 claims really weren't touched at all by the court's decision. The second case we have here is the one that Ella mentioned earlier, the Starbucks case. Again, Section 1981 claims were asserted here relating to the contracting program that Starbucks had. Here, Starbucks had committed to increase its spending with diverse suppliers from $800 million to $1.5 billion by 2030, and also had a goal of allocating 50% of its advertising budget to minority-owned and various targeted media companies. So those were some of the facts in the background. As Ellen mentioned, even though we had, again, another nice employer-side decision here, the decision did not touch on whether those programs truly violated Section 1981 or not. So we don't think that we're at the end of the story here yet. We're going to see more claims asserted against supplier diversity programs, particularly those that give specific weightings to the fact of minority-owned businesses or women-owned businesses, we think. All right, with that, we'll go to another polling question. We'll move through this one pretty quickly. This really goes to the question of tying executive pay to progress on DE&I initiatives. The second question really tries to get at the main issue that we see here from a legal standpoint, which is the program that you might have tied directly to attainment of specific targets in terms of representation rates for minority groups or certain racial subgroups. So we'll give folks just a minute to respond to this one and move along. All right. Here are our answers. About 30% do tie executive pay in some way to progress on DE&I initiatives. And then of that group, about a quarter tied it directly to attainment of targets or goals. So interesting responses there. As we dive into this one a little bit more, we see AFLF appearing again on this landscape as well. This is really not in the context yet of filing a lawsuit, but AFLF did seek commissioner's charges, one of which was involving McDonald's. There's a specific reference in that request for a commissioner's charge to quote unquote quantitative representation metrics. and the tie between those and the incentive pay for the CEO and the EVPs in that case. And I think as was mentioned earlier in Ryan's program with Paul Hastings, we don't have a great window into what the EEOC does with these requests. We're certainly not aware of any of these yielding a commissioner's charge or otherwise triggering an investigation, but it's part of the landscape that we have. Going back to the Starbucks case one more time, there was a specific reference in that matter to the bonus, the percentage of the bonus that was tied to achieving certain undisclosed targets. And the case, again, was dismissed. Importantly, just in the last month or so, Starbucks announced in response to, or as part of its shareholder meeting, that it had decided to discontinue that program as of March of 2024. So in this round, what we see really goes back to the polling question that we asked, where we see some linking of executive pay either to commitments or demonstrated commitment on diversity efforts or diversity programs to those that target specific numeric representation. So that is the spectrum, and we'll talk about best practices or tips down the road here. Last polling question, and this one relates to the third type of program that we wanted to touch on here, which is investment programs. And with this, why don't I toss the mic back to Louisa, who can fill us in on the NGS perspective.
Sure, Chris. Yeah, so we have a very long history of making investments and funding third parties in support of our mission. So the first question is yes for us. Since 2020, like many of the organizations represented here today, we've really expanded our efforts and commitment to fund a diverse cohort of grantees across all of our programs. And those investments range from small-scale investments for students or early career professionals to large-scale investments and strategic partnerships. Our programs are not based on any specific identity or trait. We don't have specific goals or numerical targets, but we are very proactive in encouraging applicants from historically and currently underrepresented or under-resourced groups to apply. So in terms of the second question, we have not modified our programs in any way since the Supreme Court decision in SSFA. But I will say, as in-house counsel, my day-to-day role has changed quite a bit. I'm much more involved now in reviewing communications about our programs and making sure that we continue to be thoughtful about our approach and spending more time updating my business and programmatic client groups on this difficult U.S. legal landscape that we're in, and sharing these litigation trends in supplier contracting and grants that you're about to cover. So, yeah.
Great. Thank you, Louisa. All right, we'll jump to the next slide. We're not going to spend time on the first couple of bullet points here. Louisa really captured that nicely. Obviously, the folks who are in the crosshairs here are those who are financial institutions or funds that are really making the payments directly to women-owned or people of color-owned entities. Obviously, Section 1981 is the applicable framework once again. We do have very active litigation in this space. There is the Fearless Fund case that everyone should be paying attention to in this realm. This is a case, again, brought by one of the anti-woke organizations. Fearless Fund is a venture capital firm that provides $20,000 grants to Black women-owned small businesses. The AAER, in that case, alleges that those grants violate Section 1981. They initially sought an injunction from the district court. The district court denied the injunction request. Fearless Fund, in the response to the request for a preliminary injunction, raised very interesting First Amendment arguments, essentially arguing that its decision to invest in Black women-owned organizations is an expression of their First Amendment right. Very strong defense, it seemed. The matter went to a 3-judge panel of the 11th Circuit, which ultimately overturned the district court in a 2-to-1 decision. Interestingly, finding that there was a substantial likelihood that the program itself violated Section 1981 and casting doubt on the First Amendment defense that the Fearless Fund had raised. So this is only at the PI stage right now. Obviously, there's still a merits determination and the permanent injunction question still pending. So in the realm of investment programs and contributions to investment programs, or making selections for investments based on the race or gender of the entity or the person that you're investing in, this is the important case that's out there right now. So everybody should pay attention to that one. We're going to move to practical tips in the last few minutes that we have here. And again, I'm going to toss the microphone over first to Louisa, who I think would love to chime in on some of these areas.
Thanks, Chris. Yeah, and thinking about the expanding the pie approach, you're going to talk about that more specifically as it relates to options for expanding your preferred providers and expanding your partnerships. But I think expanding the pie as an approach is really important, I think, not just in diversifying your supplier chain, but also in driving alignment internally. I think right now in this landscape, there is also internal backlash at some organizations. And I think it's really important to talk about, what is to be gained by diversity. So I'll turn it back to you, Chris, to kind of walk through some of these approaches.
Okay, thank you, Louisa. Yeah, the approach that we have seen and that we think probably has the best chance of sustaining attack is the expanding the pie approach. The notion here is that most organizations do intend to grow. Most organizations are increasingly relying on very broad supplier organizations. So the notion of going through a process of ensuring a diversity of suppliers on your panel, folks available to be the folks you contract with, is the first step. And then from there, rather than saying we want to move from 10% to 15% of the total dollars that we spend on our diverse suppliers, instead, just talking about growing the pie more broadly to say we want to increase the dollars that we spend in connection with our diverse suppliers, but that's part of an overall growth strategy that we have. Again, we're expanding the pie, so we're not making a decision between 2 suppliers based on race or based on gender, but instead trying to expand the dollars that go in all directions. Also, tracking the metrics. What we have seen with some of our clients that have really developed robust supplier diversity programs is that when they look at the number of or the dollars going to women-owned or minority-owned suppliers, it is very, very small relative to the existence of those organizations generally. So again, capturing those metrics, tracking those metrics, and being able to show that the program that we have is based on an existing imbalance rather than simply rejiggering the percentages seems to us a better approach. Also then building some rigor around the selection process. Again, creating a panel of suppliers that are available and then assessing each contracting opportunity based on the attributes of that supplier. And all of the attributes of the supplier, including their ability to fill the contract and the quality that they've given you in the past, showing that there is a business justification for the selection of that supplier. Will always go to great lengths to help ensure the defensibility of the program. And then finally, and Louisa really touched on this one, and I think in all of the assessments we've been doing with our clients, the precision of the language is really important. Ellen mentioned earlier expanding how you define the word diversity to include not just organizations that may be led by women or individuals of color, but also veterans, individuals with disabilities, small businesses. Those all fall under the banner of diversity, and ensuring that we're not shorthanding too much our descriptions of how we define the term diversity and what our program involves. All right, with that, we are, I think, almost to the end. On executive pay, I think we've already said probably the safer space is to tie any such pay to demonstrated commitment to the principles rather than attainment of specific targets. We're going to have to wait and see and watch in that space. And then certainly on investment programs, being able to rely on business judgment defense and also showing that you're getting adequate return on the investment, that will make courts, it seems to us, much, much less likely to second guess the investment decisions that you're making. And with that, I will stop and see if we have any questions in the few seconds we have remaining. And then Louisa, Ellen, anything else to add on the topics we've covered?
Not for me. It looks like we're just perfect timing here. You're all just ready to jump in.
It was perfect timing. Thank you all. At this point, we must conclude this session. On behalf of our chapter, I'd like to thank our sponsor, Pearl and Maureen, and our panelists, Ellen, Chris, and Louisa. We've discussed many important concepts today. Thanks again to Professor Stacy Hawkins, our sponsors, Paul Hastings and Pearl and Maureen, and all of our panelists and volunteer leaders for the incredible sessions today. We would also like to thank Otsuka for sharing about their DEI innovations. We have really learned so much and are grateful to have so many dedicated sponsors, members, and speakers bring us this important content. We will move to breakout rooms shortly. If you're joining individually from Zoom, you will be moved to a breakout room automatically. If you are at one of our in-person locations, you can turn off this Zoom and enjoy lunch and discussion. Each breakout room and in-person location have an assigned discussion facilitator that will lead a conversation digesting today's conference. Each has been provided with an agenda and discussion questions. Thank you to our discussion facilitators. One final note, once you are finished in your breakout, you may simply depart the conference. We won't return to the main room for closing remarks. In-person locations will also self-dismiss at the end of your lunch and discussion. Thank you so much for joining us for our 5th annual DEI Conference. We will now move you to your breakout.